Will also prove the recognition of the previous knowledge. Cancellation.
Item number 3.
Non-constitutional GST.
Item number 4. Item number 5.
74. I have one objection. You also may kindly. This implemented order bears the date of 18/7/2024.
3 years it is.
This implemented order. This order is the original. Bears the date of 24. My objection.
Let the Supreme Court decide.
Item number 6.
Yes, I am there. But the Orissa Industrial Infrastructure Development Corporation. This patch of land is lying vacant. They are doing not industry, nothing. And
Actually, have it on next Thursday, top of the list. Next Thursday.
Why?
Mr. Rostam may not be available today.
When there are many multiple senior managers, aren't we? That's the whole difficult game.
No, I'm for the opposite party, private opposite party, one on it senior.
I am pressing hard because of the lost law.
Next week.
Next Thursday, the supplementary.
Great. Interim order may continue.
Interim order vacated.
Interim order is significant.
The interim order there.
That's grateful, man.
Item number 7. Item number 7. Item number 1.
My lord, before my learned friend begins, my lords, I would like to apologize for not being present, my lords, physically, my lord, because I'm not well. So, my lord, I had requested my friend for a short accommodation, but his instructions were to go on with the matter. So, my friend, my lord, can make his submissions. My lord, we have filed the reply to the rejoinder.
I requested that you there virtually and saying I am not well. What do you want to say? He's appearing, Lord. I'm sure he can't be saying that he's not.
I do not know. He's saying that I am not
If I
well.
read that only here the matter, I think that much.
Actually, in a piecemeal, then there will be a, the gap in continuity.
Lord, I'm only.
We fix the matter only so that there will be a continuity.
I
And
appreciate, but only request was not your lordship have kept it item 1 twice.
that is what I'm saying. But now, irony.
This will take some
My
time.
friend wants, he can, my lord, make his submissions.
He's ready.
Are you ready with the matter to argue?
No, I'll make my submission.
I'm not ready, my lord. My friend can make his submissions if he can.
But again, it will be spilled over to another.
Not particularly my respectful submission, but it will take some time.
No, I understand. That is what I say when I get a lot of rejoinders, affidavit, which are reflected there. One entire web page has been consumed for this matter.
What I have done, Lord, I have made a consolidated list on it. If your lordship start reading that, probably your lordship will get a complete chronological way in which the matter proceeded as far as the case for promissory estoppel is concerned.
Oh.
You can start with
So
that.
what we thought was that if it is finished, then we can dictate in the open court and then. Which was-
This will take some time because my friend will also take some time to. So this may, in my respectful submission, of course, your lordships are very.
No, it is not a very pertinent question, but still I am asking. I know it was because nobody can foresee when you will get well.
Lords, the doctors told me not to travel for about a week or 10 days. So thereafter, any date my lord may give.
30th. 30th.
The 30th, my lord, if it is convenient to my lords.
If my bread lord is
30th.
just to not indicate your lordship what is this case all about. Just to give your lordship a little background of how this whole thing started. I'm Italian, your lordship, I don't want to. But I've come all this way, so I thought if I could use this.
Well, I understand the reason because there was one incident that happened in another court.
Almost 10 years after the inception, then it started a scheme which was slightly higher than the promised rate, which I agree. Now they're trying to take advantage that you agreed at that. So now according
So it's a novation of a contract.
no issue. That's how it goes.
But all that is not correct, my friend. All those agreements to terminate, they were never challenged. Promissory estoppel will not arise at all.
I will explain that, Mr. Mehta. Don't worry. You will have your
We will
chance
also
first.
explain. We will also explain. All this blood has no factual foundation. All those bloods to terminate it long ago. Blood now it is
Yes, no, I just wanted to know the broader idea that why they took a plea of promissory estoppel. That's why I was just thinking we have not applied our mind, nor we have taken a firm opinion on that. Definitely after hearing you,
that
take that
introduced
view.
after 10 years by your amendment.
So can we fix it on first? We are
My lord.
fixing it on first.
My lords.
As first and same order.
Yes. Mr. Mehta, the man is senior advocate.
These are the matters which your lordship wanted to hear relating to this particular
Yes.
One of my humble requests, my lord, the last occasion, if the lordship remembers, the lordship had noted that the opposite party state had filed a counter in a particular case, and they were directed to either circulate the counter or file counters in individual cases, and also tell your lordship that whether they want to adopt this counter for all the cases. Unfortunately, that has not been done till date.
Wait,
One of the matters,
this is not expected when all these matters which involves an identical question and we wanted to dispose of because we find, I think the spate of litigations are really pouring in the docket because of this. So we wanted to dispose of one matter as a model. I say that you have completed your the pleadings. Whether you want to adopt, it's a pure question of law. It does not, I think, no factual aspect is required. If it is maintainable, there is no difficulty, then maintainable in that sense. If it is not maintainable, then everything will fall on that basis. So that's a pure question. We wanted to argue or hear out the matter. So why you are not circulating your object, the counter affidavit? It was, I think, we were all unison on that you'll have to give.
Second issue which your lordship wanted that if we fail on the first issue regarding multiple years, your lordship may contemplate about giving other issues.
Definitely, that is what we wanted, because that is what we say. If we hold that the notice containing the multiple years is bad, then everything fall on that.
Right.
So no need to go into the merit of the each case. If we hold that it is, yes, maintainable, then we'll have to go into the individual case because every case has a unique fact. So that is what we wanted to dispose of this point first.
WPC 24264 of 25.
But why don't you circulate your counter to them? At least they should know that what stand you are taking. Will you not?
So, I have a very small, humble prayer laws. My learned friend Mr. Chaudhary, he has filed a counter. My learned friend Mr. Mahapatra wants to file a counter in my particular case. So, so far as this multiple years are concerned, I think there should be some consensus from the.
That is not that. There was already a consensus.
Then we have to pick up one case. Then we have to pick up one case to hear and all others will follow.
What I'm trying to say is that
Otherwise, every fact we cannot deal and do it. Mr. CORAM, kindly appreciate that we have to pick up one case, whatever within the discussions amongst yourselves. So one case we have to pick up and you address. Then we will decide that case and others will follow.
we don't have a difficulty, but if 2 or 3 counters come from the other side, they should agree that they will follow one counter so that we can accordingly prepare.
The difficulty is because they are filing a counter, they are making their case on merit. That is the whole problem, counter. On the day one, from the day one, I was insisting that this being a pure question of law, why there is no need for counter, but there was an insistence on their part to go for a counter. I understand their predicament, because if they do not file a counter, if something happens, then that may fall upon them. So we just permitted them to file a counter. But still we wanted to decide this point. It's a pure legal question.
That's we may file a compilation of statutes and the relevant provisions and the judgments so that we can rely upon that. If they have to file something, they may circulate that, we can circulate this.
Sir, I understand, sir. This is what you have said. This will welcome. There is no difficulty.
So that we don't have.
But it is not coming. It is only in a I would say the sounding around the 4 corners, but it is not coming in reality.
One of the cases, Your Lordship, pursuant to Your Lordship's direction, they have already filed. And that is not on today's board, Your Lordship. Already the compilation has been filed and circulated, Your Lordship.
Just imagine.
On the last date when Your Lordship was fixing it to today, I have given even the number, Your Lordship, yet the matter has not been listed.
Why it is not listed?
That's very nice.
Why it is not listed?
Your Lordship may have that office also.
What? Yes. So 19th February was the order. But later on she gave the number that it should be annexed. The copy of the compilation is already handed over. So why it is not listed?
Courts have not agreed with the view, and board has come out with an instruction supporting, endorsing the view that the composite so-called notices are permissible. And my lords, in fact, there is a recent judgment of Andhra Pradesh High Court on 2 issues: the digital signature being affixed and this composite so-called notice decided against the department. The department has gone to Supreme Court. Supreme Court has issued notice in that matter is pending. It's saying, carrying a copy of that order. In my counsel also.
Yesterday, Bombay High Court also.
Bombay High Court and Andhra Pradesh now they are consistently holding it in our favor. So far Delhi is concerned,
Only Delhi is
Delhi is
No,
against us.
Supreme, Delhi High Court judgment was full appeals have been upheld. Supreme Court in dismissal.
If subject
This is pending right now.
subject to correction, it has been withdrawn. It has not been
No, even a SLP is dismissed. It does not tempt down to merger. There is no issue.
Copy of the SLP Mallots and the order if the losses may have been I'll check you. If you want to have a look at Sahiti agencies, the losses are permitted to tender it across. Copy of the SLP Mallots like also.
What to do, you know? They are not really very much.
This is what also be included on. Company by the rules, the synopsis and the SLP calls. I didn't think it's too much, so getting over to
No, that I've seen that ground, this E is the main question we are concerned with.
It is tentatively insurance. The other side is also on KPH, so they are represented, so they should be filing a complaint. This matters. So the matter should be taken up and disposed of.
Incessant. Incessant of.
There is no stay which was granted. No stay which is.
No still.
There was a Polymer Mathur's judgment, Mathur Polymer of Delhi High Court, where SLP was dismissed. That has also been referred to the listing.
That is dismissal at the SLP stage. But this Kumayu judgment or something, 2000 volume 4 or volume 5 SCC. I could never pronounce that name.
That's right. That is a mandatory question in the AOR examination in Supreme Court. Every year that question is certainly here. So somewhere or the other, general form, that question which is there.
But each and every provision of your statute, if perceived with definition clauses, it speaks of something otherwise.
What is 74.3 and 73.3? But both the provisions, there is no restriction, there is no embargo.
I understood because I saw that there was a substitution of the word shall with the may, and you wanted to take advantage of that.
That is an issue also in the matter when the figure is appearing. That there is a 2020 notification by virtue of which that may has come in. That issue is also there in the Sahiti agency.
I have seen that.
So that discretion has been given to the authority. They may not serve that summary of purpose. That issue may not still stand covered because of the amendment. As far as the composite show cause notice is concerned, that is not pending before the.
But no stay has been granted.
This question of law B.
E is the being.
B.
This is what they.
Only validity to it.
The contention is Delhi High Court has given a view. It is maintainable. How can they take?
Ensuring the binding persuasive order upholding the validity of the consummation process.
So maybe the state commissioner has come here.
It's very much.
Question was when the public said,
When
He would ideally pray for after subject to not just
This side of the objection also.
was that he gives some elbow room notes to prepare each aspect.
Sir, everything, everything, but not. Because every day, every Friday, at least 5 matters are coming in this way. So there are 2, 3 matters which we really wanted to decide because we have been watching it that because of that, these matters are pending and really augmenting the pendency. So that's why we wanted to hear out the reason for that. We'll have to. Why you are not interested, sir? Yeah, they are enjoying an interim order and you are not really taking all kind of prompt steps. And you just invite those adjournments to come. When it was directed, the last occasion, why you will not give it?
In this matter, when seniors appeared, filing the count in the course of the day. Let's let him file a rejoinder.
Why you do not violate much earlier? So that's the whole problem. It's pending for a pretty too long, 2025.
Today also you are not ready. At least today also you are not ready. At least you could have served.
I will not sit in right now, I'll just file it. We have referred to all these developments subsequent to the Supreme Court's judgment in Polymer Mathur, and that's all referred in my counter. I will file it today.
When we can fix the matter, tell us.
May I suggest to you? Let him circulate the counter. I adopt that counter will be adopted in each and every case. After the 1 week, we can your lordship can fix and we can.
Mr. Mishra,
It is so ambiguous that we can't foresee anything on that.
Unless until you got the counter, it is very difficult on our part to back ourselves.
he will not adopt. He is filing because of subsequent developments happening in Honorable Supreme Court. That is what he wants to bring on record.
These are all the question of law. Next Thursday is what day?
It's 23rd.
23rd.
What date?
23rd.
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 First week.
First week of 7th of November.
7th. In his case, he submits that the counter On 7th. So after that, so let us see if there is any development.
Item number 3.
You show that that is complete.
The interim order in all these cases.
The compilation that Ms. Sahu had filed, let us also share a copy of this.
I have already, I'll share the softs.
Sir, we have the soft copy. I'll also share the soft copy with all the other nonsense. With Mr.
Give all the soft copy to all.
Can you give me the, make a list of all the email IDs I can send?
If the counter file, Mr. Virtual,
We have already said in course of this day, it will be served.
Item number 3.
Issue pertains to the imposition of the transport.
Here they have challenged the order passed by the member of revenue, where he refused to exercise the jurisdiction. Although there was a direction by this honorable court to entertain the appeal.
Yes, paragraph 5 was the sheet. 5.1. Lordship is the judgment. It says that there is there cannot be any transport fees when it comes from outside the city.
One point, subject to, since your lordship have already, this Bihar Odisha, the rule, that is 1965 rule. This rule was framed in terms of section 89 of the Bihar Odisha Excise Act. Bihar Odisha Excise Act repealed in 2008. So this rule continues to be in force in terms of 119 of the Odisha Excise Act 2008. And moreover, beloved, in para 5,
That is what a judgment we have relied upon. Paragraph 6 of the our High Court judgment.
yes.
But judgment
And that
is,
was of 2022 judgment. So,
You have accepted.
yes.
Issued circular. So, the circular is quoted.
Similar orders.
But no interest. Yes, making the balance, but no interest.
They are not paid. 22101, slate number 22101.
The first one. The first one.
Page annexure 13, my lord, page 10. 221.
Connected time.
Or
Item number 4.
Individual object. The petitioner is the licensee in respect of officer. There was the allegation that he was taking some extra money over the MRP of whiskey as well as the beer.
why you are taking?
It is alleged. Then the excise people,
Means
allegation the excise
there
people.
must be some.
Yes, Malak, they conducted I found also 20 rupees extra on the whiskey and 10 rupees on beer
Oh,
above the MRP. Then the SIR was drawn. I have asked to submit my explanation. I submitted my explanation. Lordship come to the impugned order, takes.
So what explanation?
I had not taken, I had taken 20 rupees for water, for water time extra I had taken.
But have you given a water to them?
I had given the bottle.
Because they were on the spot, they saw that you never gave a water.
They have bottle. I had given, I have expense that. They imposed my lord 1,55,000 penalty. Your lordship has already adjudicated, but I was the already council. They cannot travel to bear this statute.
You do one thing,
50.
you're changing the name of penalty as compensation. You're changing. Take the one, yes, no.
Lordship has seen section 64. 64 of section provides
One will take more.
the salesman has taken. The license he has not taken. This
He is an authorized sales.
Authorized
I
sales.
believe under the excise
Yes.
rules, you have to disclose the name who will sell.
my lord.
They approve it and then only that salesman
Yes, ma'am.
can sell,
Yes, ma'am.
nobody else.
Yes.
So if a fault of an agent is,
Yeah,
principal is responsible.
Liable, my lord. Lordship has seen section 64. Penalty for certain acts by licensee or his agent, servant. If any holder of a license, permit or pass granted under this act, or any person in his employment and acting on his behalf, any willful does any act in breach of any of the conditions of the license, permit or pass, for which a penalty is not prescribed elsewhere in the act, he shall be liable in case of clause A to fine which may extend to 20,000 rupees, and in case of B and C, fine which may extend to 50,000. This is the outer limit 50,000. It also corresponds to section 60. Penalty for offence not otherwise punishable, 50,000. On basis of the my lord has already decided they cannot
do
travel.
one thing, add both 64 and 68, 50/50 to the 1 lakh. And 20 is also there for this. So 1,20,000 rupees you just impose.
Which I don't know whether my learned friend has been informed or not. The challan payment has already been made, 1,55,000. If the lordship may
Oh,
kindly-
then
The instruction is-
Because they have not renewed my license.
That is all.
They have shown as area in the first application is renew.
without protest.
No, without protest.
When they have paid,
That is all. The challan,
covering letter along with the payment.
yes, ma'am. 33/2026.
Yes, I filed 11 March I had filed.
No. Have they shown any letter, they written that since it is condition precedent for renewal, so I am paying it under protest.
No.
Because it is online payment, there is no
Yes,
question of any remark to be put. Anyhow, they can immediately issue a letter along with that I am making a payment under protest. Have you given?
Well, there is no scope on online.
Oh, sir, I understand. You do not understand what I'm saying. I know that there is no question of any remark column there. But if you make the payments, immediately you will a letter to them,
No letter.
physical, saying that I have made a payment because of this, but this will be treated as under protest. You do not raise. If you do not say and you make the payment, then why not?
Yes, your lordship, sir. Thank you.
I am bound by a Supreme Court judgment if you make the payment
Your lordship has held it.
without any objection. Then what will happen?
Because the license expired on 31st March. Otherwise impaired because they have shown this is an area under section 30, under rule 35. So license is otherwise impaired to pay. Because otherwise the license will shall not be renewed.
And in fact, after hearing him, through virtual mode, that is on 3/10/2025, an order was passed, and basing on that order, he has deposed. That is what the instruction is.
Then see the annex 3. Annex 3, the impugn order I have challenged. This is the 3/10/2025.
Yes,
This is the.
basing on this 3/10/2025, he has made the deposit. For lordship.
No, I'm not people is SI is अलग क्यों?
1,50,000 per house.
1,55,000. Your penalty is 1,55,000.
Yes, 1,55,000.
This is against SIR.
Yes. Unlike 55,000. जो order ଗୋଟେ pass ହେଇଛି virtual hearing ପରେ 310 ର ଯୋଉ order ଟା ସେଇଟା ନୁହେଁ ଆଉ ଗୋଟେ virtual hearing ର order ଟା ଗୋଟେ ଅଛି ସେ order ଦେଖୁନ that entire instruction is also there now. That instruction I have. लक्ष्य 50 500 लक्ष्य 155
If you do not raise an objection when make the payment, then that amounts to an acquisition. Acquisitions, not acquisition, it's an acquisitions. You have to raise an objection when you make the payments.
That
God,
and I got the instruction whether
Maybe
it is
under coercion,
under
under compulsion, you have
Yes.
to write
yes, no. So
that
that
I made the payment under compulsion. You can't improve your case in that way.
that
You
effect
can't-
and
you
of
can't
instruction
maintain-
whether
you can't
whether he
maintain.
has paid under
Brother,
compulsion
not
or
getting that judgment right now is there.
but your lordship has decided that one
Oh, we understood, but acquiescence is also
Yes,
one of the principles,
I do
the
agree.
doctrine which is applicable. If you may acquiesce your known right that you have done.
that bit I got an instruction.
You want instruction, you can't deny that the payment has not been done.
No, my lord, the lordship is see the order dated.
You are talking that it was done because the renewal was cannot be affected.
Lordship is the input order of October to 2025. I have filed a case on 11th March. 11th March only 2026 I have filed the case.
It is a difficult proposition which you are.
Lordship has said till 11th March he had not paid. Till filing of the case he had not paid the.
No, what he may have decided to do it.
That way, Lordship at least granted one good time to obtain. He has paid.
What instruction? He has paid.
No, my lord, because the input order is 3rd October, my lord.
That's great.
No. The if the objection is
This is Mahua flower.
It's not, but under annexure 2, but they have shown that there is shortage of some Mahua flower. Lord, and I was directed to file explanation before the Superintendent Excise. And Lord, under annexure 3, I filed explanation. But under annexure 5, the collector has rejected. I filed before the explanation Superintendent Excise, the collector has rejected under annexure 5. At page
It
58.
was done by you.
Lord, it's
Where is the letter?
SIR Lord, at page annexure 2, page 19.
90.
Lord, still number 1.
Yes.
That is Lord, on physical verification of Mahaplar go down, found some quintals against so and so in the book balance. So there is shortage of so and so. But you Lordship, in the description of offense, there are
That was access, sir.
no, Lord.
This is what is we found the Mahua flower go down, found 441.04. What is this quintal?
Yes, against 4756.
750.
Yes. 15 quintals shortage.
15 quintal.
Now here in the top you Lordship find your explanation shall be submitted to the excise superintendent on without fail.
Where?
Lordship, there is about description of offense is there in the top.
Yes.
There are.
Excise superintendent without fail.
Yes, Lord, I filed under annexure 3, Lord, page 20. I filed before the superintendent excise explanation, stating that 15 go to the for manufacturing. So that's why there is differences there.
Yes.
And Lord, annexure 5, page 28. The collector has passed this order. Extract of order dated so and so, Collector Sundargarh, passed in SIR number so and so. Not done. He is saying that your submission explanation is not satisfactory. No reason, nothing, and he has no authority. When superintendent I filed the explanation, he should decide. Lord. Here the collector has decided. And Lord, 5 times. 5 times of duty has been imposed fine.
How can we do it? It is the superintendent of excise. He has to pass an order because the explanation is given to him. Still, he has not submitted any explanation within the stipulated time of 2012. But
Submitted on 28th.
yes, 120.
No, 28th time was that.
Huh?
In the order, it has been stated that your explanation within time,
No.
stipulated time 20, not in time, not in time.
That is what
Not
I'm
in
saying. This notice was issued 16
Yes, 16/12.
and
16/12, you know, I filed on 28/12.
by the
But in the explanation I have stated, on 27th, Lord, I have received. No, the explanation, the so cause was served on 27/12. In the explanation I have stated. On the next day I filed.
No. Time was given till 20th, but you have submitted on 28th.
No, that annexure 2 was served on me on 27th. In my explanation I have stated in para 1. The copy of the SR was given to the authorized person, Arun Kumar, on 27/12/2023. And hence the explanation could not be submitted earlier.
Yes, how can it be done, sir?
But if your lordship may kindly see page 19, page 19, annexure 2, at the bottom,
Yes.
Shravan Kumar received copy. If your lordship may kindly see after that column, received copy Shravan Kumar on 15/12/2023. So
16/12.
yes, my lord, 15/12, I think. Little bit.
On the day of inspection it was given.
I can see it's 15 or 16.
16/12, not 16/12.
Yes.
That is on the day of inspection it was, they have taken signature.
So
You can't say that you have received it on this.
But copy was served not on 27.
How he has put a signature of 1612.
That is 1612 that they will be inspected in my.
In the last
premises.
paragraph, in the last
Yes.
paragraph, it says that you'll have to give your explanation on 20th,
Yes,
Positively.
positively.
Yes,
You
yes.
know,
We received one
say
copy.
it was the signature on the day of inspection. On the day of inspection, and I was directed to put signature, but they served this copy on me on 27.
No.
And 28th I filed. Next day. Then the superintendent should have been.
You have written received copy. We'll
Well,
go
then
by
superintendent
the-
should have been passed order
No.
saying that no, you have filed explanation beyond date, this cannot be accepted. So you
But
have not collected as passed this
means
order.
that how can a collector pass?
Collector
Yes.
pass that order. Regarding that, we'll also grant me till next week. I'll take it.
What? This is appellate. And he has not said that I'm communicating an order of the superintendent of sites. I think it is that I am simply communicating that is different, but he is taking a decision. He says I is not satisfactory.
No reason has been assigned.
So they call it next week. I'll take instruction regarding only to that extent whether the superintendent has passed any order or not.
Collector has passed order, it is required.
Sign, how can a superintendent pass? His language is issued to you is not satisfactory. He is not satisfied.
23rd too, Lord. That is order. No, that is prior to date also. 16-2 is the Milord notice and 23rd-2 is the order.
Page 28.
20.
But a
Prior to explanation.
Page 28.
Page 28, my lord. Extract of the order 23/2/2024, Collector Sundar.
That I have not seen
SIS.
also.
But at the bottom, if your lordship will find at the bottom, it stated that as per the direction, Excise Commissioner by letter dated 19/12/2023 of the license, on the licensee for irregularities pointed out on the violation. So whether there was any specific direction by the Excise Commissioner to the collector to
No.
examine this, or
No.
it is by the super.
No, sir. No, sir.
As per the direction, Excise Commissioner.
This is the side number 3, which is reflected in this one.
Yes.
Is 19. So it was only placed to him. It was placed to him. This SIR.
With reference to SIR is.
No, peruse the SIR submitted by the.
Yes, Lordship was there in order. In order is there.
That
There
is
is that.
19 he has perused.
Lordship, just grant me one chance. Well, on next week, I'll come the records will find out.
Must be backdating his past order also. 23rd is the last date. If it's not the note, the irregular report is 16/2 and the given 7 days. That ends on 23rd February.
16/12, sir.
Yes, sir. Sorry.
What are you talking about?
No.
He has taken more than 2 months.
Yes, sir. Sorry.
Next, for his instruction next week. Next.
Or 6.
Your Lord, I was lottery winner, Lord, and I was granted with license. And Lord, I couldn't find site, Lord, so I provided a site, another site, which was Lord recommended by the collector and commissioner. And before any order is passed, the superintendent has issued a letter saying that you lift the quantity. When the shop is not opened, Lord, he has directed me that you lift the stock. Under annexure, Lord, 6.
Here my only,
But I'm
Madam Chair, only prayer is, Madam, while annexure 7, they have already gone to the collector and authorized the state government. And as per rule 151, the exemption power is given to the collector. This, if I may frame, my lord, this might go to the collector and collector might pass appropriate orders, my lord. Because under section rule 151, collector are authorized to sanction for adjustment or refund as the case may be. And the prayer in the red petition is the. Yes, ma'am.
Or lucky, I would say lucky with the bidder. But I have not been over because we have not sanctioned the site.
Yes, ma'am. No. There was a
No
site
difficulty, he will
given.
lift.
Yes, ma'am.
He will lift. We will, on your submission, will say he will lift. No difficulty. How he will sell is headache. He will sell.
Well, its license was given to a particular place, my lord. Thereafter, he applies for a change or shifting. That was pending when this notice, impugned orders were passed, my lord. If my lords may peruse the impugned orders, it is
Saying differently.
it's generalistic in nature. It's sent to every in the district, my lord.
He says different.
No, my lords.
But Alex are saying that the site, that means he was operating from the site, he wanted to shift. No.
It was not
It is
operating,
not
my lords, but license as per Annexure 3, two, my lords, it was granted to a particular shop, my lords. He was unable to, particular area, my lords. He was unable to find a suitable site to open the shop. Then he requested for shifting of the shop. That was pending when the impugned orders were sent by the superintendent, my lords. Here the impugned order, my lords, 6 and 8, my lords, are generic in nature, my lords. My peruse sent to everybody, my lords, not only the petitioner, my lords. So, my lords, in light of that, my lords, I'm saying, my lords, as per the rule 151, exempt 151, my lords.
151.
Yes, my lords.
So this is with the approval of the government.
Yes, my lords. He has already approached, my lords, the collector as per Annexure 7, my lords. My lords, I only request, my lords.
So let the collector, we have approved, let him decide.
Let them renew the license.
Let's already
The
remove
extension
as-
period has been now granted 2 months. They have not, only Millard, I have 7 days I have operated.
Advance is
Because
not
they-
in addition to a renewal. Advance-
No, now government has took a decision for extension of 2 months.
Whatever, let them take.
So let them collector take a decision. My license may be extended for another 2 months as per the government decision. Because they approved on 13/3/2026. I operated only 17 days. And for 17 days I have cleared MCQ.
So what is your prayer? We are simply not your prayer. You are saying that I am sorry. Your prayer. There is no prayer for renewal.
No, at that time renewal is not there. But I have filed in 11/3. 11/3 I have filed.
What?
Not I have paid in this case. In the interim application I have paid for renewal.
Without the main relief being claimed.
That is not continuance of shop. I operated from 13/3.
Operates, sir. The interim orders are for the need of the final relief. If the final relief is something else, how can an interim relief go beyond the final relief?
Look, they are directing that you live the period, the shop was closed. So now they'll have to take a decision.
Say that you have already approved the collector and the collector for adjustment or for abandonment, whatever be. If the collector take a decision, we are directing the collector to decide within a time frame.
No, that part and that part.
That part, but you now say that no, let them also renew or extend the time.
Extend on 2 months. The government decided to
within there to be.
You'll assume that observe that I will approach it because I'll have to deposit the fees. For extension of license, I'll have to deposit the 2 months fees.
That was
And application
that
fee.
should have been done. That should have
Because
been done within 31st of March.
Because of this Millard, they issued this letter, which is not.
How can we expect?
2 letters are illegal Millard. When I am not in operation, they're directing that you leave the stock. How can you leave Millard? They allowed me on 13/3. 13/3/2026 Millard, they have allowed. I filed IA.
Let's see, now it's a new year, my lords. The renewal process.
The new policy has
Yes,
come.
it's now the new.
What is the new policy?
I have not checked regarding the new policy.
They have not decided the existing
The
law.
time frame, this decision might be taken by the collector, my lords, in a specific time frame, my lords. if the decision might be taken, my lords, because
He'll have to also
he has to make an
push for extension.
My lords, he has to apply for renewal.
but I
my
have
lords.
to.
He has to apply for
So we
renewal.
are extending the time for renewal. What we wanted.
Renewal, my lords, but in that case also, my lords,
That is, I know the problem is of the statute,
yes, my
but-
lords.
but what? Which authority has a power to extend?
Collector. Because I'll have to deposit all the deposit before the collector and application for also extension.
It will go to the excise commissioner, to the
Collector, it will go to the excise commissioner, then the state government will approve, and because it's a new year, it's a renewal.
That is
which
regarding
yeah.
exemption
And no
151.
extension as such is there in under the act, my lords. There's a new year, new renewal, my lords.
year.
Every year before 31st March, they
What's
have
the time within this
31st March 2025, my lords.
Because of this, they are not opening the portal. I couldn't deposit also. Application.
The my lords license were issued, my lords, shifting orders. Thereafter, he could have approached my lords in the limited period, my lords. 13.3 he was functioning also, my lords.
13.3 I operated. Up to 31st operated, Lord.
You make all the fails to the collector and then
Lordship.
just send it to the.
But I filed IM, Lord. There I have right.
Everything you can make.
Rule 43 for transfer of license is in her name. Lord, that was granted, not allowed. Page, and except 3 at page 17. Not the guide on 22/9. Not the husband of the petitioner. And not 5/11/2024. Not they have allowed the renewal of license in her favor, not petitioner's favor. So not there is a 43 days there is closure. So that period now they are demanding that you MGQ duty under Annexure 9. And that cannot, it is outstill liquor shop because it cannot leave because the MGQ which has been fixed, we could not achieve. We'll have to pay the duty. Here, there is no license. On the death of license, they sealed the shop. On 22/9, they sealed the shop and they renewed on 5/11. So these 43 days, there is no license. So now they are saying that that period we pay under Annexure 9, Lord. I have paid the license, Lord. But
Included for the remaining period.
I paid. There is no dispute.
Remaining period to work.
On the date when they approved, Lord, on the date, the 5/11/2024, they approved.
25 means remaining period means what from the day.
Because on 5/11, they granted license under Annexure 4. It is in my favor. Now in the bottom, the page 19, 5/11/2024, in favor of J. Savitri Reddy. From 22/9, there is no license for this period.
What do you say?
And it's here, the demand was pursued. If I may read the remand or include order number 25. With reference to the above cited subject, I am compelled to write to you again as an urgent reminder regarding to deposit so and so from the said amounts. It has come to my notice that you have submitted an affidavit. My lords, this affidavit, my lords, I'll take your lords to that affidavit, my lords, to deposit the MF unutilized amount within a period of 15 days, my lords. The affidavit is page 22, Annexure 7.
Yes.
Whereby the petitioner undertakes to make such and such payment, my lords.
Yes, you have said.
I've taken note. On the note, no, that period, no license was there.
Oh.
When no license is there, how can they charge, Lord?
Oh.
The duty. They're charging duty, Lord. The duty will be leviable under Section 29, Lord. When there is no license at all. Lord, I have also relied upon my decision of this on court. If there is no license, there cannot be any duty or not license fee also. The three parties will not is what in.
Where is the third?
Lord, I have Annexure 10, Lord. Annexure 10, Lord, Lordship, the operative portion is para 30, page 32, Lord. Admittedly, there is no renewal of license, so and so date. In view of the matter, the petition not bound to pay any amount. However, it is contended by learned counsel for the state that the petition has to give one more prior notice in that regard. It is open for the state to take appropriate action if possible law. However, since there is no renewal of license after 1st April, consequently there is
staring at your
Oh, my
face.
lords, page number 13, the facts of this case. Here the petitioner did not.
He wanted to surrender.
Here, my lords, was shown intention not to continue. This is not the case, my lords. And my lords, if I may refer to Rule 43 of the Odisha Excise Rules, my lords. 3, my lords, renewal of license on death of licensee. On the death of the licensee, the collector may renew the license on the same terms without any fresh deposit or advance payment to any fees in favor of any of the family members of the deceased if he is satisfied that such member is fit to hold such license and on the condition that any arrear dues, my lords, for continuity, my lords. This is why it is important, my lords, and hence the affidavit period for which
That particular licensees who died. So that is there, but what he says is that you are charging a duty for an interregnum period when there was admittedly no license granted. They cannot operate without a license. This will not become an area view.
Here, my only respectful submission, my lords, is that
What is
this
the
is
meaning of the word area due?
my lords,
Due means due to the licensee.
yes, my lords.
If
Due from, my lords, we
there
have
not
to-
been any area,
because
there
this
could
is
not
an
be any renewal.
exclusive privilege
The collector
granted to
cannot
the
renew.
license holder. My lords, it's an exclusive privilege which is
Sir.
granted to the license holder, my lord.
Because
So, and the same family member without any.
have patience.
Yes.
Area due is qualified from another sentence.
From the
From the
deceased license, my lords.
So it should be from a deceased license. If he was, so long he was alive, if there is any due to him, then that due has to be paid
Yes.
for him.
Then I'm left.
Or her. Otherwise, this meaning from the deceased licensee will not have any importance.
Then, my lords, if I may be permitted to file an affidavit, my lords, because instructions I don't have, my
And
lords.
it also says it's been recovered before the license is so renewed.
Yes, but hence the affidavit comes into the picture. Here, the affidavit in the affidavit.
From where you will get a affidavit?
My lords,
What provision you will get?
my lords, if I may refer to the amendments made in the writ petition.
Before, otherwise, this word before the license is so renewed, means recovery must be done before the license is renewed.
See, as per the amendments made in the writ petition, they say that they had made all the payments and accordingly it was renewed.
So
my lords.
whatever was due or date of the death, they have paid.
Yes,
Or they are
that's the time.
they are liable to pay. He said that from the day of the death until the renewal order is passed, this interregnum period, because I can't operate,
No license.
you cannot impose because there was no license.
So I may
There
be
was no
permitted,
license.
my lords, I may be permitted to file an affidavit, my lords, because.
Sorry, we are again our judgment renewal and extension.
My lords, because this affidavit, my lords, then what was the purpose of giving this affidavit?
Here, there is one judgment of.
And the demand is first because of this affidavit and not because of that, because my lords, if I may refer.
Can you go beyond the statutory clause?
My lords, as per the amendment at para number 3, my lords.
I'm asking you, can you go, where is the portion of any undertaking or indemnity or the affidavit to be taken? It's simply the section says that you'll have to recover first and then renew them.
To that effect, my only respectable submission may be, my lords, because the license privilege is granted for yearly basis. And here, because the death of the, and
That
to
is why-
show the continuity, my lords.
That is, renewal comes.
Yes, my lords. No,
The question of renewal comes only for that reason.
yes, my lords.
So.
Because it is a renewal, my lords.
Yes, I agree. This is. It is really an affidavit in terrible way.
Yes.
Beyond the conditions of these of the act,
The affidavit was given way back 1 year late, 31st March 2025, my lords.
Understanding what is playing in our the end authority who traces his origin or a birth from a statutory provision. Do anything on that statutory provision. Where is a provision for an affidavit? Where is a provision for an undertaking? Where is a provision for an indemnity? Tell us.
Under what?
We are agreeable.
My lords, then my lords, I may be granted some time. Under what circumstances this affidavit was filed?
I just wanted to know there should be, you can't rubber beyond the conventional law.
Yes, my lords.
So
Under what circumstances that affidavit was given by the petitioner?
it is really a there is no equality clause. It is between an unequal.
No, my lords, my only respectful submission was this affidavit which is given by the petitioner, my lords. Under what circumstances he gave that affidavit, my lords? If his license was already renewed, then there was no purpose of giving the affidavit, my lords.
The
Because my lords,
interesting point is raised in the instant petition.
Hence, my lords, I was requesting for short time, my lords, I may be permitted to take an instruction of filing affidavit, my
The
lords.
interesting point is raised in the instant petition. Whether the authorities can come.
Grievance is against the character.
Issue notice on 5 after 2 weeks.
Item 9.
May I please? Options for the 5 showrooms have been filed for on 19/6/2025, your lordship. 19/6/2025 auction for 5 showrooms has been conducted. The petitioner participated and got the license, your lordship. Kindly have a glance to page 24, annexure 4, page 22.
Yes.
Annexure 4, page 22. Relevant is page 23, that NB, your lordship. Licensee in respect of Chikripada session IML shop, license issued offline on 1/8/2025 due to non-issuance of online license for some technical. The applicant is the winner of 40th phase lottery held on 7/7/2025. This offline license has been issued in favor of the present petitioner. 11/9/2025, that annexure 4, next page, your lordship, page 24. That NOC has been granted by the office in that superintendent of excise for opening of shop. With reference to subject cited, you are hereby directed.
Functioning of the self.
Yes, your lordship. 11/9/2025 and 11/9/2025, the online license has been issued in Annex 6, page 25. My respective submission that I have not operated from 7/7/2025 to 11/9/2025. For that reason, due to the offline license, I have not operated. So MGQ and license fees will be not be
demanded by the authority. So I made a representation under Annexure 7, page 27, Your Lordship, before the.
Why you are not taking?
I'll have to take it. My lord, I received some instructions, my lord, but they verified this is not adequate, my lord, since I'm not submitting. This representation will be disposed of, my lord.
Consideration.
No,
Not this.
not disposed.
Consider it disposed.
Yes, my lord.
Yes.
Item 10.
Item 10, Your Lordship, I may be.
Item number 11.
May please the lordship. And here the petitioner has issued a demand notice under Annexure 1. My lord,
Yes.
so against the demand, my lord, I have approached the Honorable Court. My lord, under Annexure 2, the Honorable Court directed that you deposit 50% of the demand and the state will provide you the corresponding quantity of MGQ. So kind of glance is 14, Annexure 2. Lord. And para 4 is the petitioner will deposit 50% demand by 19 September. In the event of deposits, you will be allowed to lift corresponding quantity on a license appropriately renewed and upon compliance with all formalities. By 19 September, my lord, I have deposited 92 lakhs. But they are not, till date, they are not supplying the stocks. Even I have approached number of times, and my lord, commissioner has recommended the case that they will be given stocks at page 32. Last paragraph, lordship can glance. They have government sought for and commissioner has given. Even then they are not
I am taking instruction. That is. Let it come.
and now Lord government has taken a decision that only 2 months will be license will be extended. Lord, how will lift the stocks of about 2 crore stocks is there?
Let's go. Thanks.
No, all are safe. In all cases, murder. Right. Even 12, Lord, item 12. Lord.
Item 12.
Item 12 safe. No, pending. All the cases are pending.
Page 14.
No, pending, Lord. Yes, no, that is interim order, Lord.
Item 13.
13, filed an appeal before the commissioner.
11. Item 12. Sub matters and 12 also.
All sub items. Sub items and item 12, same. 5 matters.
Item 13.
There are over 17 cases order has been passed. None of the cases they have allowed.
Item number?
Now item 13.
13 called.
Item 13, my lord, I filed an appeal before the commissioner.
I appreciate your resources.
Your Lord, under Annexure 10, I have filed appeal before the Excise Commissioner, and Your Lord, Excise Commissioner without giving number and
License.
Under Annexure 11 has written to the government that he sanctioned the on-sub. And in the meantime, government also sanctioned the sub. So that I'm challenging that without hearing anything, not numbered also my appeal. Nothing has been whispered in the Annexure 11. And now in the meantime, government has passed an order on 25(3). For only 5 days, the government has granted. And now they renew the license for entire year.
So this one.
Government not approved the on-sub.
Has been granted. What do you mean?
The commission has not decided my appeal.
What remains in the appeal now?
No, that has to be decided. The subsequent the things are illegal. The commission has not decided anything. My appeal.
Yes, he has been able to grant the new
Online to you.
Yes, no, that is under Annexure 11. The commissioner recommended. On the basis of that, the government now has approved the
in favor of another person.
OP number 5. I have made him party.
So you have
To then challenge this. You have to challenge this.
Because this is not the appeal they have not numbered. If that would be decided, yes, I understand. Yes.
so
Then
Council for the Minister Summons that during the pendency of the incident.
this is a short matter where
I am always apprehensive of the short pattern. But that is very long.
it is apprehending out a long tail with a short head. My lord, similarly placed persons, page 35 and 46. Lord, you could kindly see. Similarly placed licenses have been granted lease of government land for the purpose of running up this page 36 and 45.
36.
Page 36. It is a lease deed for running up liquor shop. Government has granted lease over the government land, page 36.
Yes.
Then your lordship, see page 45.
Yes.
But I have also applied for running of my OS shop. My application is as page 45, page 25. Page 25. Tahsildar has invited objection. Even Superintendent Excise has recommended page 33 to grant a temporary lease in page 33. But she could kindly see. Superintendent Excise has recommended page 33. It is requested to grant temporary lease in favor of the EPH knowledge of for remaining period purchase service. Now this period is over. Now Tahsildar has invited objection. That is at page 61, madam. And thereafter the matter is kept pending without any issue. Page 61. This is vernacular inviting objection. Pending with Tahsildar.
Yes, Mullah, I have obtained instruction from the Superintendent Excise. In fact, the matter is pending before the Tahsildar. The Superintendent, yes, Mullah. So, my lords may direct my lords for a decision to be taken. The matter can be disposed of.
Yes. Next.
Item 15.
Annexure 3, where I was directed by the Superintendent of Excise, Burgard, to shift my option to any other place. Lordship may see the last one. Annex 3, page 60. In view of the sentiment and emotion of local inhabitants and to avoid a law and order situation in existing locality in future, you are hereby instructed to find out another suitable and honorable site for shifting of shop.
We have already. The subsequent objection cannot be entertained.
Let's,
Now, my lord, public notice has been issued. Everything is completed. Matter is pending before the Lord Commissioner for allowing of my shifting application. In the meantime, the supervisor said, you leave your shortfall MGQ, man. There is no premises.
No, my lords, this annexure 3, which my lord senior is placing at page 16, that, my lord, we advise the petitioner to shift his shop because of public agitation. That, my lord, that has been stayed.
It was granted after
Yes.
something hearing.
Yes, my lord, that was challenged. My lord stayed it. My lord, I've given the stay order also with the instructions. That is still, my lord, that is sub judice, stay order is continuing. Thereafter, my lord, we have not insisted him to shift his shop. Now, my lords, he is running the shop at that exact same location, but he has not lifted the MGQ. So, my lord, we have demanded at page 27, the petitioner shop along with some other shops. We have said that we have not lifted your MGQ. Please lift the MGQ before so and so date. That's all, my lord.
Lords, may see the Annex 5. 21 November 2025, my lord, see the Annex 5. There is a public notice for shifting. The shop is closed since August.
How can it be closed? Because there was nothing, they have not issued any closure order.
No, my lord, for purpose of shifting, my lord.
So can you may ask for a shifting, but it does not mean that automatic cessation of the existing shop.
The raised objection didn't allow.
Then you can approach the giving a protection to you. You cannot do it in this way. How can you voluntarily of your own then stop the shop?
Because I
close the shop.
Once
they approach the police and then say that
yes,
they are
Lords may say Annex 7 series.
nothing.
8 they have you leave your MGQ because shop is
Definitely they will. Shifting does not mean that the license got automatically suspended.
No license during the validity of my license I had submitted application.
Whatever we submitted, then we'll have to lift the on extension of time. We are giving you extension of time.
Yes, extension bill, I will lift my lord. That is your prayer.
There is a statutory provision that
Whatever we can.
I will lift, I am ready to lift, but subject to they have renewed to my license.
if my lords will extend the time, if they can lift, it's okay.
Because they have taken a policy, everything got automatically extended for 2 months.
2 months.
So
within that, they let them renew my license.
not renewal.
He has not applied for renewal. That is what the instruction says. He has not applied for renewal. The instruction, my lord,
Since 20th March, the collector has recommended all papers to the commissioner at new place of proposed place.
License
Can I understand that so far as the renewal part is concerned, you have to apply.
I renew and I leave.
When
Lordship may direct.
period was there, you have to apply before that. Now the 2 months extension is given. Once it is extended,
Why?
then you
Yes,
can apply.
once it's extended.
why he is not applying is because the MGQ has not been lifted. So he
You
can.
have to lift the
Yes.
to apply.
But under direct, I will renew my
It
license.
got extended. Once it is extended, that means within the normal period. Where is the new policy?
I'll give it my lords. I have it with me.
31st May 2026, they have extended.
And sir, the last times somebody says that automatic extension.
It's not. Automatic extension.
Where is the provision for automatic extension?
My lords, if my lords will kindly know that I'll find out. Just handed it over.
There is a provision for renewal.
As per the policy, my lord.
There is no provision in
To
the
the
act.
actual rules, so as per the policy.
So there is a provision that they have to apply.
The renewal is there. Rule
Renewal.
48 is there. Rule 48.
Grant of license.
48.
No, grant of license for the period thereafter is subject to renewal. Period of license is Rule 48. 3 years license, maximum period of 3
Maximum
years,
3 years.
subject to renewal thereafter.
Grant
There are several provisions dealing with renewal. Okay. Then 34(3)(d) also deals with renewal. 34(7)(d).
D.
My lord, 9D, 34, 9D.
Sale notice will receive 5 years every year renewal.
No, that is what is there, that during that particular period, if they could not,
Yes,
if they could not exhaust this stock.
Yes.
So that will be carried forward, and for that it will not be accounted for
For the
the
MGQ.
further MGQ, means that would remain in the stock, and the further MGQ has to be lifted. I'm talking about 7 as well, 34(7).
Yes, ma'am.
That gives you a leverage to lift the MGQ within the expire, before the expiry of the term.
Yes, my lord.
Once you have extended the license, that means the license gets renewed or what, not renewed.
Renewal report.
The period of license becomes up to say the May.
No, my lord.
So
The
once
license
it
expires.
becomes May, then
No, my lord. The license expires on the last day of March.
that is what you are saying, that is
Yes.
the last day of March. Then why you have extended it for 2 months?
2 months. Extension means
My lord,
extended.
that
Extension means it is a prolongation of,
Yes.
elongation of
Previously.
something which is already there. I'm using those words from the judgment of the Supreme Court.
8967 versus February judgment. 89 Supreme Court, 67 Supreme Court.
Provastion the Duloi.
Distinction between, yes. Yes, bro. Distinction between extension and lease. Lease is a new grant, extension is same terms, it is extended.
Is a prolongation, elongation,
Right.
is stretching further of the original thing.
That's
This is what the Supreme Court has said.
Yes.
So it is a continuity. There is no gap.
If there is a continuity,
No,
my lord,
they
in
cannot do
the
that.
recent policy, my lord, then I may be allowed to take instruction on that.
This is what is here. You said that is the last day of March.
Yes, that
But
is the statute.
once you extended it, then what
On that
remains?
extension, my lord, I have no, my lord, I'll have to take instructions, my lord. So far as the petitioner's case, my lord, in this case, my lord, we have simply said that you please lift the MGQ. That is all, my lord. We have not
The
even.
MGQ now. Lift the MGQ.
Yes. There is also, if my lords will see at clause 8, there is also a rule, my lord, which stipulates 10% fine. That also we have not resorted to. We have
No,
simply
you cannot,
stated
because we have extended.
that, my lord, but we have simply stated, my lord, you kindly lift the MGQ. That is all, my lords.
I will lift the MGQ. No, only my prayer because I had submitted an application with statutory fees to seek measure of other location. They have approved. They have sent to the commissioner for ratification. That is pending. During pendency of my shifting application, they have now raised you lift your shutdown MGQ
The government, my lord,
from January to March.
That you have to lift it because you have to continue operation at the state.
And at this time, there is a vehement objection because school.
Whatever then they were.
Lordship says that I am ready to lift, ma'am.
Yes.
The authority has to look into my demand. I'm ready to. This is the difficulties. I cannot lift the entire MGQ.
Not a difficulty at all.
17.
Yes, please.
Page 104. 114. 104. This is not there in the policy and he has no jurisdiction. What? This is not a part of the policy.
31st of March 2026.
And this challenge is made by you.
Yes, yes.
Interesting.
But to the policy as well as to this lecture. Because we have got licenses for 5 years. So we are in the middle of 5 years.
Months. I think the power to issue the circulars is also vested in this statute itself.
Section 90. Section 90.
For rule making. Power of the commissioner is section 5. Section 19 in rule making power.
No, issuance of the circulars.
Circular, my lord, 91, article 91 perhaps. Section 91.
I'm aware of the another state excise act, so that's why I'm thinking it has to be there.
Well, it's 91, 92.
Yes.
Or to regulate that car. State government may issue such order and take such measures as may be deemed appropriate to regulate consumption of liquors or to enforce prohibition in whole or any part of it. They order them. Order for what? For both the things. For regulation and prohibition.
Regulation.
No, that is a different issue. State government. Circulars, I'm just talking.
How to
Again.
issue circulars.
Administrative circulars.
And where is the power of the commissioner?
Single excise, it is there.
Commissioner of power group.
That we are searching.
Commissioner has no power. It is state government.
There are a lot of judgments of the Supreme Court on that it has got a statutory force or a recognition.
That is
So far as the excise, the circulars.
Hidden chemical in excise matter.
And we'll check.
The central excise.
Correct. Check.
Commissioner is given power
Again.
to issue.
Under the act.
Statutory circular.
Under the act.
True. That is what I am asking.
Yes.
So earlier in OST Act,
Yes.
section 20, that was liquid. So this can only be taken as guidance.
At the highest.
No, that's true.
It is not in exercise of any of the
No,
powers
he doesn't say that.
conferred on the.
Not the state should say what is the source of power.
Power of the commissioner. Power of the
Section 5. Section 5.
Section 5 of the excise act.
Function of excise commission.
Commissioner's power is here. Yeah, but
Delegation and they have elaborately it has been stipulated. Mostly the commissioner power is to augment the revenue on behalf of the state in excise matters.
Licensing authority is the collector.
Collector on behalf of the state government.
such a power is not there.
No. Power to issue this instruction, the circular.
Such a power is not there.
Not there, man.
It has to be there.
What you may see 5 L to perform such other functions and to exercise such other
Delegated to him. The delegation means that the authority who is delegating such power must have that authority to issue circular.
Yes, ma'am.
But where is the authority? Then who is the authority to issue circulars? To us.
Only government, but that
State government.
State government also, it says that it can make a notification must be published in the official gazette.
That is-
Section 91.
Yes.
And then notification as declared shall be deemed to be for the purpose of the act. This is what then it has to be notified in the official gazette, otherwise can't.
It can't, that's right.
And then regulation is issue such order or take such measure as may be deemed applicable like the consumption of the liquor or to impose prohibition. So that is 93 is a difference. Where is that? You ponder upon the things. We can't do it in this way. We can't. But there appears to be a conflicting stand in two matters.
But my lords, in this case, my lords, coming back to this case, it is not clearly not so, because my lords, if you see the date of the letter, it's 25/3/26. Excise policy comes into force on the next day, 26th, my lords. So that cannot. They have simply not insisted on the fine as of now. They have only requested to lift the MGQ. That's all, my lord.
By what time?
By the end of this month is what they say, my lord.
So,
lift the short.
because it's kindly consider
Yes, my lord.
section or a rule 34(7) says that it is up to last day of March.
March.
They are challenging that particular extension. If ultimately it is found that the authority does
In
not
this
have.
case is not challenged, my lord. That is the my lord's that is, I think, the
very next day.
We'll have to, in this matter, which we are going to take, since you have extended for a period of 2 months, that means the period of license or the validity of the license is still there, and MGQ is to be lifted within the validity period of the license.
Fine, my lord. My lords want to analyze
So
that part.
if we say that it is there, now they say that you can't issue this, you can't extend. If we hold that you can't extend, and here we say give an advantage, is it not
Yes, ma'am.
diametrically opposite?
So let this lie over, my lord. Let the issue be
That is
settled
what
first.
we are
Yes, ma'am.
thinking. Let us
Yes,
let us hear out the matter and let us see. Let us see. Let us hear the another matter. 17. What is the ground? Let us see.
Because the ground is this, that 104 seeks to curtail my license period. Kindly will not see first page 19.
17. I can also say one.
Kindly see my lord, page 19.
Page
19. Annexure 1.
19.
19. Annexure 1.
Yes.
The date is 26 February 2021, my lord.
Yes.
This is when the government introduced lottery as a method of settlement of exclusive privilege. Lottery may see last 4 lines.
Yes, as I said, decided by draw of the lottery.
Grateful. I'm grateful. To you.
No difficulty. Then
Now, dear lordships, kindly turn to 12/6/23, Annexure 2, page 31. Annexure 2, page 31. Now, this is a sale notice, and this is a very important document. For settlement, my lordships have it.
yes.
Sale notice inviting application for settlement of exclusive privilege on Indian-made foreign liquor and
Country liquor through a
Yes.
lottery for remaining
Yes.
period of 23.
for remaining period of 23.
So
Now kindly
in the mid of the
So
period.
kindly see minutes. Then after the 2 tables, exclusive privilege shall without prejudice to any other provisions of the said act and rules be subject to the following conditions.
Yes.
Now, if my lords are kindly pleased to come to Roman 8 over the page.
Yes. Yes.
I'm sorry, lords. Your lordship may just see currency of the license at page 31. I'm sorry. Roman 2. The currency of the license shall commence. My lords have it, my lord.
From the date of the
The date of issuance of the license and failure to. So date, that is the commencement. Kindly turn over the page, my lord. 32 Roman 8. My lord, this is the heart of
the exclusive privilege
once granted shall continue for a period of 5 years, including the year of grant, the present grant,
Correct.
unless otherwise directed by the state government. The exclusive privilege holder shall renew his license on terms and conditions generally prescribed by the state government from year to year till completion of 5 years. So not once. Why is they say 5 years? Subject to annual renewal.
Now, my lords may kindly see one more point.
And also there, unless the state government otherwise direct.
Comes to a finding. I'm grateful.
So it is not that 5 years is
5 years.
completely inviolable or.
Your lordship may see page 34. At the bottom of the page, S, small s. The state government reserves the right to refuse to grant privilege without assigning any reason therefore, and settle the privilege before expiry of 5 years.
That is what is there because.
Yes.
That's
So
the
what your lordships are very good. This is like the lion and the lamb clause. But anyway, we'll come to that. Let us
Not
see
even
the first license.
The bull in a China shop.
Kindly see page 42.
Both.
So kindly see page 42. Yes.
40
42. Now this is where I am granted the license.
is 20. This was license was granted.
This was the license minutes, and the period is, your lordships will see, from 1st April.
Yes.
After the license will remain valid from 1/6/2023.
46.
I'm sorry, 36/2023
Mid period.
to 31st remaining period. Now kindly see, my lord, the next page. Your lordships will see this. The last license is at page 46. If your lordship sees page 46,
It is from 1/4/2026, 31/5/2026.
31st of March, 31/5/2026.
Yes.
Your lordship is right. Now, my submission to your lordship is, you gave a policy. Your policy said it will be 5 years. You issued a notice for sale notice. You said it is for 5 years. You kept on renewing me year to year. Now you say we have a new policy under which we will truncate it. So therefore, my lord, the result is that people have got licenses for 1 year, 2 years, 3 years who have operated. The result is that you told me 5 years. I took the license for 5 years, subject to renewal each year. And you found me to be a satisfactory license for all these years. Now suddenly you say, at 104, no, it will end in 2 months. You can say, if you found some difficulty in me, you could have said you have not performed. You have said you have violated lease conditions. Now let us see what happens in a lottery.
What is the meaning of this word?
Yes.
This is what is there.
Yes.
Subject to the state government. Otherwise, unless otherwise directed by the state government.
Yes, your lordships are reading page 24.
Yes, I'm 32.
Yes.
Roman E.
And 32.
Roman E.
Yes, my lords. So therefore, what it says
So it
is,
says it is always subject to
correct.
the direction of the state government. 5 years is not really inflexible.
My lord, direction has to be in public interest. It can't be because I don't like your face.
Whatever is there.
And now let me tell you, lordship, what is the object? Kindly see, mills. What you do by lottery is basically the what I will pay to the government is fixed. So why they gave you 5 years? I'll tell you, lordship, the logic is this. Because whether it is he or me or he or Mr. Rath, we only become licensees. We get the exclusive privilege. All other considerations remain the same. The revenue collection is same. You are just changing X to Y. Therefore, the policy was conscious. The first policy which was made in 21, that we will give you for 5 years. And there is no loss to the state revenue by way of this new policy. What this new policy is to do? Not to increase the revenue. Just in place of me, it says in lottery XYZ will come. So what is that great public interest you are going to achieve? My submission is, you give me a license.
Larger involvement of a public, the larger generation of an employment.
No, Millard, how come? Millard, I will be out of employment. No, Millard, I go out of employment. Millard, I go out of employment.
Money and somebody will come. So at least there will be some uplifting.
Millard, the purpose of this act, Millard, the purpose of levies under this act.
Who is for the state? To find your activity.
Millard, there is a small problem. The problem is this, Millard, that this extension is only given to me for 2 months. So my interim application.
They will further extend if you want.
Your lordship may hear the interim application, issue notice on both,
Issuing notice on both.
Not hear it, please hear it in the last week of April.
Within 2 weeks.
File your option. I'm grateful.
Just keeping this matter and decide it on that because many matters are.
Because of that.
Your matter is also.
There is one other matter, if your lordship will just take half a minute. That is the last but one, where the application fee has been increased from 1 lakh to 3 lakhs. So it's a compensatory fee. There is no rationale behind this. Let them file a reply on that also. And it can come together.
Why only 3 lakhs? Why?
Only to augment revenue.
Why only 3 lakhs?
Yes. An application fee. Your lordship may issue notice on that.
Only 3 lakhs.
This poor
Non-refundable.
That is also non-refundable. Other states are 20-25,000. Your lordship may issue.
Think of it. Let the government think or ponder upon it. If something can be done.
25.
184.
Again, same tag. Grateful.
On 2 grounds solution. On demand notice on 2 grounds solution. That is the license fee has not been paid and the shortfall of lifting the molar leak. MDQ also. I have taken license has been awarded only in the month of end of August also, but the charging is from April 1st also. That is the first contention also. Secondly, MDQ has also been targeted from April 1st, whereas I have taken license has been awarded only for 28th of August year until February end year, not even the end of the 31st March year.
Yes, it has to be done in a pro rata basis. What you are doing?
I'll take instructions from you.
Take instruction next Thursday. You come. Do it in the pro rata basis. You do.
May I please let you know the fresh admission?
Yes, yes. Will again. Great.
Item number 18.
Both are same. Both are same. So those are 2 different shops. 17. 17.
Great.
Item number 18.
Item number 18, Lords, I am appearing virtually. This matter relates to GST, and in this matter, my Lords, 2 parallel proceedings and 2 orders have been made, assessment orders under section 73. 73, my Lord, 73
Yes.
of the CGST Act.
Yes, yes.
Lordship may kindly see Annexure 1. Annexure 1 is ASMT 10, which is the notice for assessment on the scrutiny of returns by the superintendent of CGST Dhenkanal. There are 2 points, if I may kindly place. The first relates, they have said that I have short paid an amount of 8,432, which I am liable to pay.
And the ITC you have claimed of 13 lakhs and odd.
Yes, that was in excess.
Yes.
And that they have asked me to reverse immediately, my lords, in
You
ITR
did
9.
you did not file an annual return for the year 2017-18, sir.
Yes, yes, my lords, I have filed. Lordship may kindly see Annexure 9. And Lordship may see page 65, it starts on page 69. I have reversed the tax.
Page?
Page 65, it starts. I mean, the GSTR 9, as the Lordship's pointed
Yes,
out.
yes.
And I have filed GSTR 9. And Lordship may kindly see page 69, running page 69. I've reversed. If your Lordship may see, point right from the top, I. Column I, total ITC reversed, if your Lordship gets it.
Yes, 0.
6,76,645 is CGST. 6,76,645 is SGST, which comes to about 13,53,000. 4. So that is the amount that they have pointed out that it is to be reversed, and I have claimed excess ITC.
Yes.
And at this point is settled here. And finally, the one in Annexure 2, Lordship may find DRC 01 with the superintendent has passed, and final order that he passes, Annexure 4, page 33, Lordship may see.
Sir, this order is of 23, sir.
Yes, my lords, I'm placing that the superintendent's final order.
Yes.
If your lordship may
Now you have a right to go for an appeal.
My lords, lordship may kindly hear me. Just consider one issue. He has asked me to pay 8,432. He is satisfied that I have reversed the ITC. There is no issue relating to ITC now. So this matter, so far as the superintendent is concerned, is closed. 8,432 I have paid already, and this matter is settled. Now, what happens? Another officer, he assumes jurisdiction in this matter and starts the process anew by giving me a show cause notice under 73.
No, this was under the state or the central who has initiated this.
But that is the central authority, because my jurisdiction
Central
is
authority.
Central authority.
So where is that?
Let's come
No, another authority at what? Where is the page?
Yes, my lord. So I am coming to that page. His final order is on page 23. The final order he has passed, he has initiated proceedings. The lordship may see Annexure 3, page 23. Annexure 3, I'd like to place the para 2.4. It starts from page 20, Annexure 3. Same section 73 of CGST and GST has initiated.
No, I understood. That was which was the earlier order. I think the page 20 is the earlier order.
No, this is the order by the Assistant Commissioner of Cuttack.
It's 33.
This is 20 and page 33, Annexure 4, the superintendent concluded the proceedings under the section 73 and asked me to pay 8,400 something. He was satisfied that the ITC which
He was satisfied. Mr. Lal.
Yes, madam.
The superintendent in his earlier order was satisfied with regard to your reversal of ITC.
Yes, madam.
In the annual return.
Yes, madam.
Now again for the same period.
Yes, madam.
Annexure 3.
Annexure 3, I'd just like to place two paragraphs.
Just doesn't. This is original 1, 2.
Dr. Lal?
Yes.
Dr. Sharma?
Yes, madam.
Can you take us to that portion where under Annexure 4,
Yes,
page 33,
yes, madam.
that aspect has been considered?
No, that he has not mentioned expressly about it.
So
He has not mentioned expressly about the.
So that issue was not taken up. That issue was not there in that.
They don't write
Where
comfortably.
is the show cause with respect to Annexure 4.
Annexure 4.
Where is that show cause?
Yes, my lord.
42.
Order is first, then
That
the
is
proposal is
Annexure
letter.
5.
My
That is,
goodness.
Annexure 5 is the show cause by the superintendent.
Sir,
Yes,
my
my lord.
query is
Yes,
with respect to Annexure 4,
yes, my lord.
where is the show cause?
When Annexure 5 is the show
This
cause
is
notice
at
by
page
superintendent.
42.
42, 17, 2,
Is
43. Yes.
he has not talked about anything about the wrongful availment of ITC.
Yes.
He did not.
No, by then I have already reversed. He was satisfied that I have reversed. It is on record. Everything is on the portal. Everything is on the portal. There is nothing hanky-panky here.
This is after a gap of 2 years. He is coming up.
I may submit. I had ITC available of 6 lakh.
So that is what there was no occasion for wrongful amendment of that.
May I please place para 2.4 of the impugn order on page 23, Annexure 3.
Dr. Sharma, better you approach the authorities. Otherwise, there is no other.
The authority knowing fully well, because it's on record.
No, it
No, the difficulty is, Mr. Sarma,
Yes, my lord.
that you have filed a writ petition way back in 2025.
Yes, my lord.
You are challenging an order of 1st December 2023 and 15 December 2023. 15 December is in your favor, you are not very happy. 1st December 2023. There is already a provision for an appeal. There is a time limit which is given in the appeal. Whether the writ petition after the expiration of the normal period of an appeal is maintainable.
This is a question of jurisdiction arises here. He has jurisdiction.
I don't think so. Please read the GlaxoSmithKline judgment of the Supreme Court.
May I also please plead your lordships to see page 55.
Are you aware of the GlaxoSmithKline judgment of the Supreme Court? GlaxoSmithKline judgment of the Supreme Court, are you aware?
If I don't file proceedings within the stipulated period schedule, which is provided.
No, the apex court has in categorical terms says that the writ petition should not be entertained if it is filed beyond the period of limitation provided for an appeal.
Well, Lordship may give me a week's time, I'll examine that.
Yes, please examine, please examine. Please, that is what is there.
For your Lordship's appreciation, that there is no revenue loss in this matter.
Sir, when you talk about the striking at the root of the jurisdiction, when you say,
yes, ma'am.
then this is also striking at the root of the jurisdiction of the writ court.
Yes, ma'am.
You may have a good case, but if your remedy is barred, if there is a fetter, what can be done? That is what troubles us.
This is not a case where we can say that it is lack of jurisdiction.
You have a citation of Glass?
Yes, I'll provide.
And you will give it to him. You just go through it.
Yes, my lords.
Next week.
Yes, I am obliged, my lords.
Item number 20.
19 of actually.
One of the petition to the exporter of iron fines to the overseas biofuels. There is stipulation.
First appeal letter has been challenged, Your Lordship, but in the prayer, Your Lordship, we find from page 21. Preliminary admission. Your Lordship.
He has a remedy by way of a tribunal.
Your Lordship.
You can go to the tribunal now, you are within the time. Madam, they have extended. Go for a tribunal. Fine.
One.
This into multiple assets.
Matters are there today, but they did not argue.
Item 22.
Item number 22, 73, 4B of the finance.
What happened to Supreme Court?
Tentatively tomorrow. Tomorrow.
Item 23.
Item 73 4B.
Yes. Item 24.
24 already registered RAMAN.
Item 25.
Cancellation.
That's principle. Item 25.
Yeah, 25.
Yes, Lordship.
What is that? Cabinet order is challenged.
It was
I don't know, on the ground of delay we have seen. Go to the.
without giving an opportunity.
Whatever, you go to the tribunal, it will take care of something. You are within the limitation now for tribunal. Go there. Yes.
Item 26.
The buttons to 73 4B. 73 usually.
4
Item number 27.
27, may I please, Your Lordship? It's 73 4B.
Yes.
Item number 28.
Agreed for the cancellation of deficiency.
Item 29.
No, other issues are involved, Your Lordship, but primarily clubbing of periods is there, Your Lordship. So I am handing over a corrected order.
Sixty four weeks.
No, Your Lordship.
Oh, it's a clubbing of multiple.
Yes, Your Lordship.
That was there, you did
Yes.
not argue. Then you, yes.
Item 30.
Cancellation of possibility.
Item number 31.
It's not even RC cancellation, Your Lordship.
32.
In this case, the petitioner is that work contractor providing service of Amnesty. In 2019, government of Ministry of Finance will introduce a software which are similar. Petitioner approached the authority
Software scheme, SBR, DRS scheme, approach the authority, where the designated committee approve. Lordship, now petitioner bank account is attachment. And that certificate is to under BDRL code, Lordship.
Can is the annexure 7, my lord. That is another so-called notice which relates to, my lord, manpower erection, commission and installation service, manpower equipment and supply service, work contract service. Page 7, running page 31. This adjudication relates to this so-called. The impugned order relates to this so-called fact. This 5 lakh somewhat, my lord, is the demand. 5 lakhs 5,047.
Lordship, SBDRL 4-1.
That was another man. That was for cargo handling. That so-called which my friend is referring, that was for cargo handling and that was settled in the amnesty. Yes. And this subcargo stuff. That has been settled. That amount was 6 lakh somewhat. And this is another matter that is for the same period.
SBDRL 4-1 is
To be taken up.
As a whole, why not?
My lord,
all period are covered.
answer this.
No.
Yes, my lord.
Can you do it piecemeal that?
No, it should be, but this so-called is different, my lord.
So what? Amnesty scheme, does it make a differentiation in the?
No, my lord. But that amnesty scheme relates to cargo handling, my lord. A so-called was issued for cargo handling and that was settled under the amnesty.
In the amnesty scheme, is it restricted to only cargo handling? Or amnesty scheme is wider?
A amnesty scheme is wider.
So once they have approached, will you not cover the entire claim which is made?
But that the application which they have filed, that relates to that so-called only. That so-called, that first so-called, that annexed to so-called.
Total period.
6 lakh somewhat, my lord, that is the.
No,
Where
is the term of the amnesty scheme per person
Yes, my lord. That is
with respect to.
period.
So, can you, is there any ambiguous distinction between the nature of works or nature of business, varieties of business carried out?
No, my lord.
Is there any?
No, my lord.
But then how will you? That period is covered under amnesty. Then
Maybe other different things, but whatever.
is a proprietor, I think.
Yes, my lord.
Proprietor.
partnership.
But my lord, this amount is not covered there. That is my.
Why?
Lots of period.
He has approached, it's a poor person for him. Is it?
Yes, my lord.
File response.
Yes, my lord.
Next the application. Have you annexed the application?
Yes, my lord.
Lordship. Where is that application?
Lordship, SDVRL 1, Annexure 3, Lordship. It is 27, Lordship. And the certificate is page 29.
27, it refers to this first so-called only. If your lordship will see 27, that amount is 6,58,274, which relates to that annex of 2 so-called.
Here it is cargo handling service.
Cargo handling service. Under the head of is also there, it is cargo handling.
So he is not audited. You did not disclose at that time all your.
Lordship, that scheme is covered total period.
Sir, will you not indicate is this? While you have identified that amount, while you have shown the category, would have said all categories, total demand.
Lordship.
You were not aware that you have been given a show cause notice, they are demanding.
on a different score. Lordship, after the SDFBR report, Lordship, discharge certificate, they are issued.
Discharge certificate related to this cargo handling.
Sir, specify this amnesty scheme to be availed in respect of cargo handling service only. You have never brought to the notice of the Almighty Commissioner with respect to other services or other business activities which you are carrying out. Isn't it? So demand is raised in
Correct. He asked for a particular device. Amnesty scheme. You want to do it. Why you did not aware of it?
You have a registration.
Lordship.
You have a registration.
Lordship.
In that registration, all your activities are mentioned.
Lordship, cargo handling service.
Only cargo.
Lordship.
That was possible.
Fine.
Why your responsibility? Consider.
Lordship, meantime, my bank account attachment will be
Because
What is the demand?
demand is 25 lakhs.
so deposit 25 lakhs.
Lordship. Initial their demand is 5 lakhs something, Lordship.
How does it shoot up up to 25?
Lordship, interest penalty.
Interest and penalty.
Lordship. Lordship, as per
What is
demand
the
about
component of interest? What is the component of interest? Where do we find?
Lordship, total.
Demand is
Lordship, service tax demand is 5 lakh 5,000. Lordship.
interest. You have said 25 lakhs, including penalty and interest. Then what is the component? Bifurcation.
Lordship.
Within 4 weeks, so that they will, within 2 weeks, within 2 weeks, so that they will consider that
Lordship.
attachment.
Lordship, tax amount. Lordship. Lordship, tax amount is.
Which pays?
Lordship pays 51.
51 the details.
Return deposit with you. Tax amount.
Tax amount.
So far as the interest or penalty is concerned, while your affidavit will consider. And attachment should be immediately listed.
On deposit or
On deposit.
Deposit and tax.
Page 51.
Annex 10. In like interest and service
Penalty shall remain.
Item 33.
So there are 73 points.
34.
Actually, the RC cancellation.
Yeah, all separate.
First item I am addressing, second item.
Yes.
Second item.
Yes, your section two. Yes. We have collected here also. Yes. Item 35.
Editing the notification of one. Editing the notification of one.
Notification 9 and notification of 57, extending the period of limitation regarding that.
Connected Pradeep. 34 connected.
Thanks.
36.
I think 74 bills.
Minus. Item 37.
There is a problem because we have decided one case on a mode of service. We have Mr. Mishra, mode of service, which matter?
My lords, I don't able to record the name of police. The mode of service, my lord, irrespective any 6 mode of service can be appropriate, sir.
Correct.
Yes. But this case, your lordship, the notice has been not been served on the petitioner email ID under 1969C. But not on the email ID of the managing director, your lordship.
Incorrect.
Yes, my lord.
Incorrect. Then it's a different.
Managing director.
Yes, my lord.
One is an alter ego of another. He is an alter ego of the company.
Constructive.
But the statute that is sought on the
What? Is he not? Is he not?
Yes, my lord.
Board of directors, they manage under the Companies Act. They become responsible. But he, the board of directors, he is one of the directors. He manages and administers all affairs.
But it's not subject to amending the communicate the.
You must have given the email address for correspondences by the department. What is the mail address which he has given? What is with the
That will be verified. But this is additional service. Subsequent service. The service has been uploaded. Once they have been uploaded in the portal, that is a valid service as your lordship has already decided 169.
Whose name? Whether you wanted to adjudicate upon the managing director or the company?
It's 75. Oh, it has been uploaded. It has, the assessment has been done in the name of the company.
So, the query is whether you are going to adjudicate the managing director or the company. If it is company, then what is that mail address which the company wanted you to correspond?
Mine is putting submission. That I verified.
That is
mine.
That is it.
No. When you say you uploaded, now we'll have to see that uploading of that particular notice or whatever was in what portal. I mean, assigned to a company or it is a managing director in a.
75 euros. Even though I'm not the answering party, but I'm a party. I'm a party opposite party number 2. It's 75.
No, when you are there, then whether it is answering or not answering, you will definitely answer.
Sir, you are drawing your attention to order, not order. He is alleging notice.
Notice, sir. You are talking about orders. That's the problem with Mr. Mishra because he's so energetic. He gets jumbled up between the order, uploading of the order and the notice.
Yes, come to page 48.
He's saying that I was not given a notice. So if there was no opportunity, then.
Mr. Das, while furnishing return, you must be mentioning some email address?
My lords.
Can you demonstrate from your repetition?
My lords.
What is that email address which you have disclosed to the department? Or your registration certificate? There is no column.
The government made in the repetition of lordship.
Maybe, sir, but we want to know which email address you wanted the department to correspond with.
On your time, have the last repeats number 11, page number 11. Page 11.
Number 11 is part of your government, no? You want to
You have to sign on page 60.
document which you have furnished.
Page 60. 60. No. The notice has already been uploaded. The notice has also uploaded.
Uploaded with reference to what?
How many years?
Yeah, do I?
60 years. The name Akhara Enterprises India Private Limited.
I want to know paragraph 11. He has mentioned that one email address he has given. Right? This is he claiming as a registered email. Whether you have uploaded notices and orders in his email. Mr. Das, have you Mr. Das,
that mail ID
received this assessment order or this adjudication order? In which address?
Registered mail ID.
This, which paragraph 11. But notice was not there.
Not mine.
In this.
Yes, ma'am.
So, may kindly page 67. The copy. Accounts 1.
No, sir, there is a gap in between. That's why I was just trying to figure out. He has typed the email as such a very unique fashion. It's very difficult to find. Have you noticed the email? There is a space between accounts and one. And in the top fourth line, very interesting. We can't figure out whether it is a continuity or it is a space. One character, if it is not, it will go to another mail or it will bounce back.
No.
What he has done is that see accounts and then on here.
I'm just explaining. It's not done that. Sir, that is automatically taken. That underline, that blue, it comes.
That it is, however, no intimation for such and such was served on the registered ID. Here you find this is the registered. He admits that this is mine. This is fine. Now that is underscore. Underscore cannot be. It is not. Email does not. No. It should be one character. It is a multiple characters when you are using it.
This comes. Even when this is a Gmail or something.
Whatever, I know.
It comes underline.
No, that is not a part of the email.
No.
It's not a
But
part of it.
so by printing, that comes up. So by the so it is.
No, that is, I'm not. I'm just talking about because here is the government doing that one. We are a special character under the scope between accounts and markets. Because you must have one special character. Only you. You should. This is what it was. It does when it has come. Yes, if you see, he has a typed in this fashion, whether there is a gap or there is no gap. I'm unable to find it. Because if one character goes, then it will bounce back. The email, all these things are one, but there is a difference of one underscore or gap. Gap cannot be, but underscore definitely has to be there. So Even your paragraph 11 is very clear.
There is a one additional S is there in the manual.
No.
Yes, my lord. There is only one S is extra in the address nearby.
What are you talking about?
Can I have glance to page number 12, para 5 your lord. Page serial number 5 your lord, please.
I am looking at page number 12, sir. Where do I get a extra S?
Only extra.
Oh, this is ESHARES.
My lord, that's
Yes.
That's the only difference, your lord.
Yes. No, this is a difference, brother. In this, after RA, nothing is there. But here, after R, another is A. What is the difference?
That is easy.
This is the personal one S is there, S in the group is no, that is GS.
So they have made that mistake. They are strict managing revenue, but I want getting the registration certificate.
I must compliment your client. Very innovative. Very innovative.
While people taking this fee, I also confused many times.
No, he's a very innovative. He should be applauded that he can create a lot of mess for a confuser. And he's capable of doing it.
Mr. Das, it is your acumen.
No, his client.
My brother is complimenting you.
But the merits
But
of
his
the
client.
speak that
He has committed a confusion, knowingly very well that what may happen. One factor missed create a hell of a difference.
But the merit of the my lord.
Intelligently, he has done.
Now, Mr.
Even Mr. Mishra will not be able to say anything about it. No.
Good. Get that particular. It is submitted by Sri advocate that the department has never issued notice.
No, never.
Never. Company. I need to open up. You can never be proper. Because you are sharing one major share, 50%. So how can you be proper one? Stake is with you.
That will not 38.
2 weeks. Mr. It is 2 weeks.
Yes,
38. I'm praying for 1 week after.
2 weeks.
Item 39.
ZM Wallace. ZM Wallace.
All the sub items?
All sub items.
Who is appearing? Have you checked?
Yes.
Yes. Item number 40. All sub items who are appearing in all sub checked. Item 41.
This is the matter in 1819. Because though there is a complete stay of recovery of demand under section 2 of the subsection 6 of the Tax Act, Lords. As the matter, your lordship, in terms of this memorandum that's issued by the CBDT, 20% has already been deposited, and the matter is pending before the first of letter. But thereafter, in consequential assessment, your subsequent assessment, your lordship 25-26, I am entitled to get a refund of rupees 40,80,000. Sorry, 14,80,000. Because that amount, your lordship has been adjusted, though there is a stay.
Can it be?
Under
what provision?
subsection 6, another order was passed.
Yes, Lord, that is Annex 1.
During pendency of appeal.
Yes, Lord.
Then.
So,
You are defying,
It is
you are
system
defying your own orders. You are defying your own orders.
Is a system generated? Very interesting. So system has to be corrected. When you will correct? When you will correct? Tell me.
Everything is mechanically done. No human intervention. Then why to appoint officers? Only to put a digital signature.
Where is the, show us the page number, where is the order under section 220, subsection 6?
Annex 1, page number 19, starts from 19. And lordship, relevant page, Lords, 20, paragraph number.
Yes. It's seen that the preferred an appeal against the demand order and has already made a payment of being at 20%. Yes, at page 20.
Therapy, lordship.
Stay is granted. This was enough first.
You complied with.
Yes, the deposit is there.
Yes, your lordship.
He has written 20% deposit at page 20 last line. He has acknowledged it is deposited. Stay. Appeal is pending.
Yes, your lordship.
Where is the adjustment?
Adjustment, your lordship, page 22, Annex 2, page 20.
So this was in relation to assessment year 2018 and 19.
Yes, my lord.
Yes, that is there. So how can you do it, sir? It's apparent. We'll have to reverse. And the assessment order was passed, then you were entitled to a refund of this amount. Assessment order for a subsequent assessment year was passed, assessment was done.
Yes, Lord.
You were entitled to a refund of this amount, which they have adjusted.
Yes, Lord. So that is page 51, and also I'm entitled to get. Page 51, Lord.
This is the assessment year 25-26.
Yes, Lord. So exact amount 14,80,470.
Yes. Brother, that's true. How much? How much percentage?
This is amount 14,80,470. Interest at 6% versus 240 per capital.
Payback. This is what is to be done. It is refunded. You can refund. Let me-
When was it invested?
Page 51.
Adjusted annexure
51.
Page
12.
Yes. Page 22 minutes. 22.
Adjustment.
Adjustment page 22.
22.
Yes. Next up.
The date.
Date, Your Lordship, 27th January 2026, Your Lordship, tender date.
Yes.
Before tax breakup details.
Yes, 27-1.
Yes.
Yes. Ebar. Yes, yes. Next.
Item 42.
Here we go. The petitioner in this case is a distributor of FMCG, Your Lordship. Fast moving consumable goods.
I know.
Your Lordship, petitioner was issued with an intimation dated 23rd February 2026. The said intimation is an intimation directing for payment of the amount of late fee for non-payment or for not filing of GSTR 9/9C, Your Lordship. Your Lordship, kindly have a look at Annexure 1, page 14. Please. This is for the period 21-22, Your Lordship.
Yes.
Your Lordship may have page 15. The reasoning is there. It is observed from the records available on
Page
15. Your Lordship. Para 1.
Yes.
It is observed from the records available on the GST portal that you have failed to furnish GSTR 9/9C for the financial year 21-22, which violates the statutory provisions. Hence, as per the provisions of Section 47, subsection 2 of CGST OGST Act, you are liable to pay a late fee of 100 rupees for every day during which such failure continues, subject to maximum of a calculate at a 0.25% of your turnover in the state or union territory. Accordingly, late fee has been calculated, which is payable by you as follows. Your Lordship may see there is no breakup as to how it is calculated for what amount. There is only a calculation that you have to pay 1,20,000 for this period, Your Lordship. And it is said that if you don't pay, recovery proceeding under Section 79 will be initiated. Lordship, there are two things that arises out of this, Your Lordship. First, if at all I pay the late fee, there is no provision for the filing of the GSTR 9/9C, because Your Lordship may find at Annexure T, Your Lordship, I have attempted to make to file. It says that you are not allowed to file because you have crossed the 3 years expiry period, Your Lordship. That is one thing, Your Lordship. The second thing, Your Lordship, is Your Lordship may have a glance at Annexure 19. For the subsequent period, that is starting from financial year 22-23, the rate at which the late fee is to be levied is reduced from 0.50% to 0.04%, Your Lordship. So Your Lordship knows that a beneficial legislation can be given a retrospective effect if that is at all taken into consideration, Your Lordship. Then 0.02 and 0.02, 0.04%, it comes to a nominal of 19,000 rupees. That is one, Your Lordship. And secondly, Your Lordship, subject to payment of such late fee, I can be permitted to file, Your Lordship, the returns as well. Because my turnover is 2 crores, so 9C is not required, Your Lordship. Only
So 21-22 is included in this circular notification.
No, that is not.
Next year, Your Lordship, immediately preceding.
Proviso.
No, proviso, I am just reading at it.
Provision 30th June, up to 30th June. This notification is for a specific time period.
Yes, sir.
Okay.
First day of April 23rd to 30th June 2020.
So when was it filed?
It's not filed. I'm not able to file. That is why I've given that.
And as per section 44(2), after 3 years, annual return cannot be filed.
Also, your lordship, like that.
Clearly says
So what will happen thereafter?
they have to pay the penalty.
Oh,
No,
then what will happen? Will they be permitted to file after 3 years?
That part I have to take instruction.
Hmm?
That part I have to take instruction.
So is it not a permanent commercial death?
Lordship, because that return, that becomes.
Can they apply a fresh GST? I'm just asking you.
That question also come to my mind. For that reason, at the beginning.
You have always an answer to all questions.
No, this, there is no answer.
There is no answer.
Now you have answer. Honorable Supreme Court in Babulal Sapuri. Odisha High Court case. He talked to Honorable Supreme Court in 1960s.
This is somehow, I think I have to take instruction.
In the additional. Of course. Means that when you take, when you receive some, otherwise there is no meaning of this late fee.
Last week also I had the department because all over Odisha, your lordship, all over the state.
Is only in this state.
This type of notices have been issued. Your lordship, so it came to my knowledge so that I had discussed.
But
with the
I think this is centrally, this is a central portal.
State also because this.
It is a central portal.
Pan-India.
So it is, yes, pan-India. So whoever has committed the similar, anywhere, same.
And also it has been clarified by CBIC that levy is to be levied. This has been clarified.
Is to be levied, then what consequence?
That only, that the procedure.
Question is, she's also not saying that late fee cannot be done. She has raised two issues. First issue is that you have calculated on a particular basis. You have not indicated the details that for how many, what rate or what thing you have charged. Secondly, says subsequently you have reduced the quantum of the penalty or percentage of the penalty. So according to her, if it is a beneficial to a necessity, then this particular notification should be given a retrospective effect. That is her argument. Our observation is not there. I understand the moment you started, I know. So we are not saying, nor this is our opinion. This is what she has raised. Now the question that fell for us, that suppose if we say that no retrospective operation, it has no applicability. And whatever the calculation you have made is correct. Let us go to that extreme. In that event, if she pays, then what is the next remedy available to her? She be permitted to now upload the return?
Only on this issue, your lordship, only on this issue I have to take instruction.
This is what is required.
Because the provision itself says, 44(2), your lordship says that we cannot file, no annual return can be filed after 3 years. So by that, I have calculated that 3 years has been lapsed, so he cannot file in the portal.
Then what happened?
So that part I will take.
Then there should be something more.
Your lordship, that part I will discuss. That part I will take. Only on that issue.
And right to apply a new GST number is a dangerous one. It will have a larger ramification. Nobody can imagine.
So much of complication, your lordship.
No complication. You do not know
your lordship.
The other aspect. Yes.
Yeah.
Lordship, on the IA, your Lordship will pay for stay until they file the counter because the intimation says that unless you pay, so it will be recovered under section 79, your Lordship.
1 week, nothing is going to happen. If they come, just mention the matter. You just take care, at least for a week. Next Thursday, because you are asking for. So,
If they find that I'm
when,
not.
when he is there,
Not necessarily. 1 week after your Lordship may kindly.
next Thursday.
Yes, ma'am. Item 43.
Lordship, if the matter was filed and this was pending, it was there in the list for last 2 weeks. There has been some development. I need to take instruction on Lordship. Lordship may keep it to next week.
Item 44.
These matters will be section 73.
Sub-item 4. Forty-five. Yeah, sub-item.
All sub-item 3.
Item 46.
Alert, the matter relates to cancellation of RC 46, 1 and 2.
46, matter relates to 7340 of the matter.
Sir, sir.
46.
We have called 46.
Yes, ma'am. 46.
46 is talking about cancellation.
Sorry, my lords.
46 is mine.
Okay. 47.
46.
73 4 being.
Pragya Tharichand.
73 4.
6, 73, 4.
47.
47.
73 4.
Okay. 48. All sub-items.
In the second sub-item, I have I'm appearing, I have sub-item 1 and 2, 1 and 3, and he is.
No, you are appearing in which one? You said 9898.
And you are seeing 9898 2026 and 10249.
10249.
Yes, sir.
Yes. And who is appearing in 9885?
Yes, I'm applying for.
Same. Yes. And who? Yes, these are the 3 items.
Rajesh Kumar Tripathi. Rajesh Kumar.
Yeah.
Item 49.
Dismiss. Dismiss.
So much. 49.
Item 50. Your Lordship, item number 50, both matters are identical, your Lordship. Besides your Lordship 74B, your Lordship, another issue is there. That is the issue, the review, I have challenged the review order of the passed by the Commissioner, your Lordship. The review order itself has violated the limitation, your Lordship. The review order.
They wanted to file the appeal.
The review order is to be passed as per section 84. Of 3 months. Its identical order is there. In that case, your Lordship, the difference is that. The difference in that case and my case is that in that case the appeal was pending. In my case, the appeal has been disposed of, your Lordship. So for that reason, the last paragraph I have subject to your Lordship's correction. I have rectified the last paragraph, your Lordship. All others are same. The last paragraph it is subject to your Lordship's acceptance, your Lordship. There, your Lordship has stayed the proceeding of the first appeal. Here, since the appeal order has been passed, your Lordship, only your Lordship, no corrective action to be taken, your Lordship. And all others are same. Violation of 80.
Last line, that the authorities are directed not to take any coercive steps in terms of the What I.
This is the same unit.
The listed, this has never been listed.
It is written in the hand, no courses. I have.
There's a case, there has been a flagrant violation of, there's been a
Flagrant
violation of the principles.
Flagrant.
I have
Not
borrowed-
violation.
No, I have borrowed this particular word from your lordship's own order.
I borrowed it from somewhere.
Registration, my lord, in this particular case was cancelled with effect from 6/12/2020, my lords. That is Annexure 4 at page 26. If the lordship will kindly turn to page 26 for a moment. Here, your lordship would appreciate it. The top right-hand column, lord, is the date, 6/12/2020, my lords. And the effective date of cancellation, my lord, is 6/12/2020.
You wanted to discontinue your business.
Lord, I wanted to discontinue because after the corona period, my lord, this is a hospitality sector. It did not take off. And there was a non-filing of return for which my registration.
What is the hospitality sector? The hospitality sector becomes boom.
No, it was in a place of the present, where the present petitioner's sector is concerned.
Good.
And if your lordship would kindly see, so far as the liability is concerned, it's all zero.
Correct.
And if your lordship would kindly turn to page 32 for a moment, lords. This, my lord, and at page 33, if your lordship would see, I have filed my annual return in GSTR 9 with effect from 7/2/2020. That is much prior to the date of cancellation. And after considering pardon? Page 33, my lord.
Yes, 2020. Yes, I got date of filing.
Date of filing 7/2/2020. It's filed. It's GSTR 9 and GSTR 9C, my lords. Same date. So, my lords, as on the date of cancellation, this particular return was available, and they had, my lord, determined my liability as zero. Subsequently, my lord, the same particular officer, if the lordship would mark the name, one Mr. Panda, he issues a show cause under section 74.
74?
Months. Under, my lords, Annexure 1 at page 14, my lords. Little realizing, my lord, that he had 2 years back had cancelled. And after cancellation, Lord, there was no occasion for me to access my portal. Lord. And ultimately, Lord, this particular SCN was issued and an order was passed on 31/8/2024, Lord. Then, Lord, I came to know about it, Lord, when my bank attachments were made. And from the bank, I came to know that this particular
What is the mode of service?
Portal, no.
Portal. No. Is there any other mode of service there?
There is no mode of service because I'll come to that now. After your lordship's order in a unregistered case, Lord, the commissioner, they came up with a circular. And if your lordship will kindly turn to that circular, Lord, at page 7, they say it was, of course, a case of 63. At page Annexure 7 at page 34, people ask me. They have said that in these cases, and if your lordship would turn over the page, that they have said that the physical mode of service has to be adhered to avoid further litigation.
True.
So here, my lord, knowing fully well that my registration was cancelled with effect from 2020, the same officer, my lord, in 2024, he gives me a SCN in my portal and ultimately passes that order. And they, in my humble submission, Lord, the petitioner will be deemed to be an unregistered dealer, Lord, and the physical mode has to be, Lord's, adopted to Lords. And that having not been done, Lord, then I have very humble submission, Lord, it vitiates, Lord, the entire order.
He has to ensure service.
Because he is the same officer, Lord. If the lordship would see, Lord, the officer, Lord, passing.
This is our order.
But that
This is our order.
Assis Kumar Sahu, Rasis Ranjan Sahu.
And also after getting this brief, I have already discussed with the commissioner to modify this notification to look into at the time of issuing notice to look into the portal about the status of the RC. Already that is there. Commissioner is going to issue a notification. So in this case, let it be set aside with a clear cut. Your lordship at fixed date. Your lordship let him appear. Your lordship it will be discussed. It will be decided. Your lordship
that is a good piece. Once the cancellation has taken effect much earlier,
I have already.
how can they have an access to the portal?
And my liability is zero.
Setting aside, why? Is it coming within the fold of 74 at all?
Well,
That you answer. Setting aside and asking him to appear, what purpose it would serve when ingredient of 74 is not attracted?
I have filed my final return for 1780 in February 2020 minutes. And when they cancel my RC, they show my liability is zero. That's Annex 4 minutes. So they're aware a lot of my return and my return figures. And by no stretch of imagination that would be available for the authorities to resort to in this particular case.
Bring out material that it attracts fraud, misrepresentation, and what?
Suppression,
falsity, whatever.
Suppression.
As your lordship knows, the order is very much here.
So, you are asking him to go and approach again. Why should he appear?
Admittedly, it is an expert your lordship. So, admittedly, no sufficient your lordship.
Admittedly, you are saying
opportunity your lordship because we can assume that once the registration has been cancelled, no one will touch the portal again, your lordship. Because as per his appointment, his business has been closed. So he may not touch the portal again for filing for looking into the order. So that is admitted, your lordship. And your lordship, for that reason, I pray let it be set aside to the assessing officer to for reasonable opportunity.
material on your record.
And so that is. What is there? He also understood why not 73.
It's only for the time period 3 years. So my learned friend will agree to that. Having not gone for a 70.
That is true.
The circuitous route to go. Nailing me down. And if your lordship not have a lordship, you continue that proceeding at a 74 because he doesn't have
You file objection then.
Sorry?
You file objection, then he will consider it.
Not great respect, he doesn't have that power.
He will consider that objection with regard to whether he would proceed or not. He will first consider that.
The lordship of slightly see laws. The reason is mismatch.
It will be just like 148A Income Tax Act.
Unnecessarily not dragging the person to another round of litigation laws with great respect.
It is open to you to take a plea that there is no ingredients of section 70.
You don't have the power. With great respect, it's only the appellate authority who can convert a 74 into a 74 proceeding. So once he issues a notice under 74, unless your lordship directs so, he can't convert this to a proceeding under 73. As per the statute.
We cannot also because time, we cannot also. Time has come.
True, my lord, but time is settled. But your lordship would appreciate, Lord, in order to save that limitation, he has resorted to 74, even though the fact remains that 74 is not applicable to the facts of the present case. And I have filed my 2A, I have filed my 2B returns, and by no stretch of imagination, even if not there's a ITC mismatch, it will be a proceeding under 74. There's no element of fraud at all, Manoj. And time and again, I also have tried to elaborate at what is fraud. There's no element of fraud. I have declared my liability.
We'll decide this point. We will say that what a fraud would mean. I think that is very much required in 74 case.
Recently, we have indicated certain aspects under what are the safeguards you have to.
That is in a separate. Some paragraph.
Come with those concepts on the fraud from Lazarus estate to the recent one.
Float is float, I think, under excise or service tax, afloat under Supreme Court. And thereafter many cases.
I remember the earliest one, the first foundational case, Lazarus estate.
The Lazarus estate is referred to there is in afloat. And thereafter many cases will.
I'll get that.
Out of court, I can submit.
We are take instruction. Let them.
3 weeks for me.
Yes. My learned friend agrees, my lord, that the lordship will convert this to a 73 proceeding, not has no hesitation to again appear.
Can we?
The limitation part, I'm
So if you wait, can we?
Your lordship will decide. Lordship will decide. I can't, my lord. At least to a position, my lord.
I think
jurisdiction part, this should be my prayer instead of my learned senior. Because your lordship admitted.
I think both the provisions are operating in different fields as well as notices are also different.
That's section
Not one.
75. Your lordship for a moment.
Not like earlier OST saying that strike out whichever is not.
That I admit, your lordship. Only submission before your lordship in Article 226.
We'll decide on the ground of fraud. Let them. Yes. Become 52. 73 conversion. Consider that whether the court should resume that power.
That should be some adjudication. Admitted should be some
Come there. 52.
The department has done the top part class down.
These matter relates to section 73.
Yes. All these sub items.
Yes.
Who is appearing? In all the matters?
Yes, in all the matters.
Is there 73 for the issue, my lords?
Yes.
Item not 53. Please. The parallel is commercial. Lordship may grant me 2 weeks time.
This is the third occasion.
Third officer.
They have received.
On 12 month, they have received.
I have already
received.
Because 12 month is taken time for inspection. Again, 26 month also. Because I have fulfilled the demand, 77 lakhs with 10% fine. I am liable to leave my corresponding MDQ.
Why you are not permitting him to lift the NGQ? Mr. Das? Why you are not permitting him?
MGQ has to be lifted within that particular year, man. Although That
Sir, in the subsequent year, we have already, in many of the cases, we have permitted them to lift along with the NGQ of that particular year.
but only interim orders have been passed.
So whatever,
So far as the,
so we are again passing an interim order.
let me just file this.
So this is what, do it. You want that the system should work or the system should collapse? It is, they're ready to give you our money.
They have deposited 77 lakhs since
So,
2 years back.
They are
2 years
only-
back.
They
Customers say the
are
annex of
only
course is-
depositing the excise duty. But
Yes.
so far as the material cost, they are not depositing.
That
But you are not a manufacturer.
Yes.
Are you a manufacturer?
But if they will get that product from the Odisha State Beverage Corporation, only by paying the excise duty, they cannot get the entire material. They have to pay the material cost.
Malord, this point was
Material
made-
cost as well as the excise duty.
Malord,
Both
this-
has to be paid. The
Malord,
excise
this
duty or
point-
What is the source of the existence of this breweries corporation? Tell me.
State Beverage Corporation, my lord.
The Companies Act.
Yes.
So maybe solely owned by the government, but is a company,
Public sector under.
is a company
It's a public
under
sector
under the Companies Act. Then difficult.
It's there. They will have to live.
It does not go to the exchequer of the government. It remains the corpus of the company. And then the board of directors, they have to take a resolution how to direct the money or they invest the money.
The excise duty is paid in different head of account. That is government expenditure.
That is what, because of the shareholding pattern of you are distributing the dividends.
That is why.
Last time also, my lord friend, I raised same question. Because I have paid the entire excise due to 10% fine. Now what will happen, my lord? I will pay the price of the product after reduction of the excise duty. I am ready. As soon as I have also calculated.
Once he has cleared the excise duties with the penalty, then he is entitled for renewal of his license.
Renewal, they are-
But so far as lifting of the MGQ is concerned, that is as per the provisions of the statute and subject to payment of the material cost.
Section 15.
Lordship, may allow me.
Section 15 what says, my lord? Section 15 of the Orissa Excise Act. Then charging section 29 what says? On sold.
1 week time we are giving as a last chance, you file your. Otherwise, you have received 1 week time. By next week, they list the matter on that day. Yes.
What is your outcome of annexer 5?
Yes.
Annexer 5.
Yes, they have repeated the corporation whether the order of the Honorable High Court is implementable or not.
Who is writing?
The Lordship, the government has written to OSBC.
To say.
In large number of cases were filed where my lord
is
directed
writing to the State Beverages Corporation saying that in batch patterns, High Court has passed 50%. Then if whether that is implementable or not, we give report. That outcome, that's what I'm.
Let them give outcome also. Let's call the next item 54.
or fresh admission.
Item 54, I'm praying for adjournment for second time. Your Lordship, for second of 1 week only. Your Lordship, the country is ready.
Third time they are taking.
Second time.
Third time the order.
Second time.
Order is.
The first day is the order day. The second day I have sought for adjournment. This is the next day. And I am seeking adjournment only for a period of 1 week, Your Lordship. My counter is ready, sent for vetting and signature, Your Lordship. Only Your Lordship, that will be sufficient. For that reason, in a maximum, I am paying 1 week.
Right.
Let it come on next first year.
Yes.
Good night.
Item number 55.
55, Your Lordship, pertains to faceless assessment.
On last occasion, Lordship had issued notice on 19/3/2026 for instructions.
Similar metros have been directed to East of Southern May. So this metro may be discussed in May along with others.
Yes. Give the number. Entry order to continue. Item 56.
Let's look what I think. Petitioner's note is the manufacturer of palm oil. Manufacturer of palm oil.
Palm oil.
Palm oil.
Palm oil.
Palm oil.
Yes. Palm trees. I am aware of that.
So here they import raw palm oil, crude palm oil, and they have a manufacturing activity in the state where they convert it to palm oil.
They import palm oil.
The crude palm oil from Indonesia mostly comes from Indonesia.
Crude palm oil.
Palm oil is not after this manufacture, they manufacture.
Then
palm
they are
oil.
refined.
They are refined. So in this process, my lord, here, my lord, an inverted duty structure occurs, my lord. Because an inverted duty structure occurs, my lord, and the petitioner, they are not entitled to a refund, as your lordship knows. Here, my lord, a refund was for that period was calculated and it was granted. Subsequently, an audit was conducted, and after the audit, proceeding logs under Section 73 log was initiated. My preliminary objection, the Lord, would be that against an order of refund laws, and that is also the CBIC circular, the appropriate mode not after a particular post-audit law is an appeal under 107, not a 73 or a 72 proceedings. For that, Lord, if your lordship would kindly permit me, Lord, this will be my first point, Lord, before I take your lordship.
Department has to challenge that refund order.
And Lord, the CBIC and the CBIC circular is also very clear on what would happen in these inverted duty structures, Lord, which culminates in a refund. What is the method to be adopted? The lordship would kindly see. I'll go to the other points, Lord, because if I make my first point clear, Lord, this is relating to the subject of the law would change. Procedure relating to sanction. Sorry. I'm sorry. Procedure relating to sanction, post-audit and review of refund claims regarding. Attention is invited. Subsection 2 of Section 107 of the Central Goods and Service Tax Act 2017, which provides that the Commissioner may review any decision or order, including an order of refund, with respect to its legality or propriety, and he may direct any officer subordinate to him to file an appeal against the said decision or order within 6 months of the date of communication of the said decision or order. Reference is further drawn to entry number so and so, the pre-audit table number so and so. The lordship will skip that. Whereas it has been stated that pre-audit of refund orders is not required to be carried out, but post-audit of refund orders may, however, continue on the basis of extant guidelines. Subsequently, the board has been receiving reports of different practices being followed by the field of formations regarding sanction, review, and post-audit of refund claims. In certain commissionerates, speaking orders is being issued in respect of all refund claims, whereas in others, speaking orders are not being issued if the refund is sanctioned in full. Similarly, in case of review and post-audit, different practices are being followed by the field of formations. The matter has been examined with the twin purpose of ensuring uniformity in the procedure and enabling effective monitoring of sanction of refund claim in order to safeguard interests of the revenue. Accordingly, the board hereby issues the following instructions for sanction, post-audit, and review of refunds. The lordship will skip all the things. Straight away will not come to paragraph 2.1.2. 2.2.2 is the relevant portion, but I'll begin with 2.1.2 millions. It is mentioned. It's mentioned in the ACS GST portal provides the facility for uploading a document in the PDF format along with so and so. The same may be utilized by the proper officer for uploading the speaking order along with the refund sanction order in form GSTR RFD 06, so that the same is made available to the applicant as well as to the post or reviewing authority online. Then post audit of review and review. Subsection 2 of Section 107 of the CGST Act provides that the Commissioner may examine any decision or order, including an order of refund, with respect to its legality or propriety, and he may direct any officer subordinate to him to file an appeal against the said decision or order within 6 months of the date of communication of the said order, decision or order. The said subsection they are reproduced in subsection 2 blocks. Then the law may kindly come to 2.2.2. Accordingly, as per the extant practice, all refund orders
have to be required to be reviewed for examination of the legality.
And if the Commissioner is satisfied that there is not a ground of review, he may direct, that is the subsequently they have said, he may direct Milord to file an appeal. And this Milord, in order to save limitation, Milord, the Lordship may kindly see, Milord, so and so, the post-audit review is there till 2.2.5, till the time of functionality of conducting the post-audit online, and come to the 2.2.4, the procedure. The post-audit and review of the refund claims shall be conducted as per the following guidelines. All refund orders passed should be immediately transmitted online. C. The post-audit should be concluded within 3 months from the date of issue of Form GST RFD 06 order. The finding of the post-audit shall be communicated to the review branch within the set time period of 3 months. The review refund order shall be completed with at least 30 days before the expiry of the period of, allowed for filing appeal under Section 107(2) of the CGST. So my humble contention now, the first core issue in this particular notice, whether a proceeding post-audit, a proceeding under 73 is permissible or my humble submission would be, Lord, since the appeal period for this particular sanction which was given, refund sanction was given, done in 2022. The audit was taken up in 2024. So the 6 months period as per 1072 has already elapsed. So they resorted to this method of 73. Even though 73 begins for erroneous refunds, in my humble submission, that erroneous refund would relate to refunds which are claimed in the returns, and after scrutiny of returns, if there is some lacuna, they can resort to 73 or 74. But this particular inverted duty structure refund, this order, is always amenable to an appeal to be filed by the Commissioner if he is not satisfied. 73 proceedings out of question. Secondly, so far as the present case is concerned, they depend on a circular. That is Annexure 10, to say that my raw materials and my finished products are the same. They say, raw crude palm oil and refined palm oil are one and the same commodity. They say what you have done is only you have added.
But impurity has been removed.
So it is a processing method, not manufacturing.
Obvious one.
But one of the Supreme Court judgment for sales tax regime, I think RP oil, perhaps 1998 or so. Whether that is manufacturing or processing, that is decided.
No, it is a very recent judgment in 2025 also. The court has said manufacturing and process. These are the two different concepts. One loses the originality and gets converted into another. That's a manufacturing process. Commercial commodity.
And it is a distinct
under the different head or the category for the purpose of this. But if it is processing, then it is something which retains its originality, but in a more refined or a process.
It is now my product, final product has a distinct commercial identity of its own, and it cannot be at any stretch of imagination will also be compared with the crude palm oil.
No, it cannot be.
Cannot be. And the Lordship would see this particular
Say in a recent scenario, the crude petroleums, they are being imported, but they are being refined and converted into a petrol, sometimes diesel, sometimes in a, the aviation, the fuel, the aviation fuel. These are the 3 grades or 4 grades.
And many byproducts are there, like
these are there.
Kerosene, tar, and all those byproducts are there. And if the Lordship would kindly say, they rely on this Annexure 10, page 226 circular, which the Honorable Delhi High Court, the Rajasthan High Court have said, it is not at all applicable to the case of a refund in case of an inverted duty structure. If the Lordship would, they rely on
That is BP oil mills.
BP
versus sales tax tribunal. It is 1998. I am not taking the citation. 1998 INSC 355.
355.
It's a neutral citation.
Now it is converted to neutral citation, but STC citation I have forgotten. I said it is 1998 STC somewhere.
I'll check it. So this particular
that takes care of the other industries. Then this one PO food packers, then chocolate. That I don't know. The processed and what is processing, what is manufacturing. It is the process of crude oil undergoes radical change itself to marketable refined oil. That is what the processing of crude oil to refined oil.
And this particular circular on which the learned friend wants to take instruction, protect me, give his time. So otherwise, what has happened, Lord? They have reversed the entire law. Now they say that you have to pay back the interest, the
along with penalty.
Along with penalties.
It has to refund to this.
That's true.
Some. I'll argue on the next day. I don't want to open my mouth.
Very difficult to beat my learned friend even at 430 minutes.
Without instruction.
Very difficult to beat my learned friend even at 430. He's also with me.
For yes, there is 57 is over. That is the that's last item. Yes, it's called 57.
Please, my lords.
Yes.
Please, my lords. The issue is, my lords, there is a non-speaking order, which is a verbatim reproduction of the entire show cause notice, my lords. And that too without giving me an opportunity of hearing, despite me applying for the opportunity of hearing, my lords. If my lords will have page 35, my lords, that's the impugned order.
No, your lordship may kindly come to page 36. Your lordship has already heard this matter.
But that's a different assessment.
Wait. Let him, it is his chance, let him place. He has page
35, my lords.
Yes. Sure.
Page 35 is the order, my lords. If my lords just go through the order for a moment, my lords.
Yes.
Page 55 is the show cause notice, my lords.
Page
55, my lords.
Yes.
Both, my lords, page 55, 56 and page 35, 36, they are verbatim reproductions, my lords. He records that I have filed all relevant documents to establish my claim of credit at page 56, my lords. If my lords will have page 35 and 36, my lords.
Yes, I understood. Now, yes, here table.
If my lords will have page 56, my lords.
No, let me.
My lords.
Yes, you have replied with a copy of the tax invoices and return filing.
My lords, that I have done to the pre-show cause stage, my lords. The pre-show cause stage is the DRC01 at page 45.
Page
45, my lords.
that is the pre-show cause stage.
Pre-show cause stage, my lord, they issue me their intention to issue a show cause. That is called the DRC01A. That's at page 45. Now they tell me that there is an investigation against my supplier, whereas he is not in existence. There is no investigation against me, my lords. And I have to establish my claim of credit. I respond to them at page 48, my lords. If my lords will have page 50 for a moment, that is part of my response to them, my lords. Para 3. Page 50, my lords, page 50.
Yes.
That is my response to that. There's DRC01A. I specifically tell them, my lords, at para 3. If my lords will permit me to read.
You are saying that we are saying a triple transaction without any supporting the materials. You are unable to give reply to that.
Yes, my lords. He doesn't give any material on record to establish that my claim of ITC is incorrect, my lords. He blocks my credit, entire 54 lakhs for 3 assessment years, my lords, and makes it a negative block, which is not permitted in law, my lords. That is also under challenge today. And then he issues me a show cause notice, which I showed, my lords, at page 55, passes an order at page 35, my lords, which is verbatim reproduction of the show cause, my lords. No findings.
That I have noticed. That I have noticed.
My lords.
Sorry, I missed the page of show cause notice.
Page 55, my lords.
Yes.
In fact, my lords, if my lords will have page 56.
No, I'm just looking at the date.
Please, personal using page 54.
4/2/26. And this letter, this explanation was given in, you have taken a decision against this DRC1. This DRC1. How you received the reply?
DRC01, Your Lordship, he has replied.
Where is the reply?
Your Lordship, that reply.
This was issued on 4/2 and his reply at page 48 is 12/1 in the month of January, and this is issued in the month of February. How can he give a reply prior thereto?
Your Lordship, Your Lordship, for a moment. Your Lordship. 280, 285. Subsequently, he has replied, Your Lordship. His reply has been considered. Your Lordship, page 285. Page 285 is the 11th February 2026. And 20th February 2026, twice he has replied. 11th annexure.
I have not replied on merits, my lords. I have responded to them.
Page 285 to 293.
Because I have not responded to them on merits. I still ask them at para 3 that kindly give me the relied upon documents. Kindly have para 3 at 286, my lords.
And your lordship, again, he has all given all the.
Let us see, I understood. But where is a independent finding on that? I have checked only the difference one can notice. I'm giving you from page 35. I am telling you the difference will come from GD 1210. That's the difference added. And then you have replied, he added, and show cause notice above it, show cause notice, which was in present tense, is now used in a past tense.
Your lordship, I admit that there is not in many words.
So not many words. Where is the words?
Your lordship,
Where are the words? You tell us. Many will come later.
the suppliers are non-existent, your lordship.
Where is that?
Those have been produced, those have been provided in your lordship in the notice.
Sir, there are many things. In non-existent, that at one point of time he was existent. The GST number which is shown, he must have checked. You have to say that this GST number never exists. It exists in the name of another person. These are the findings which you will not say.
And where is your finding that vehicles are not utilized?
Never
utilized. Not a single vehicle has been downloaded.
So nothing has been done. There is absolutely non-speaking order, non-application of mine. Consider again.
Demand and fixed time. Direct the petitioner to cooperate in the proceeding.
He will. He has to. He can't protract the litigation or prolong the litigation. Definitely
They have
not.
time. I'll participate, my lords. I'll participate, my lords.
Your lordship may fix up a date. Your lordship.
All litigation, non reason, brother.
Well, there's one more difficulty, my lords, if I might point out. My lords, page 30.
And
My lords, if I may point out one small, my lords, difficulty, my lords, they have made a negative blocking which is not permitted, my lords, at page 30.
I understand, sir. We are on one ground. We are just remitting it or let it come on Monday.
My lords,
Item 66 will not. Item